Cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky, we're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people.
Good morning and welcome to W4Nevada Live. My name is Matt Winterhawk and you are tuning in to W4Nevada Live's continued coverage, day 14. Coyote Springs LLC versus the state of Nevada. $1.5 billion takings claims against the state. Honorable Judge Mark Denton will reconvene today. We're doing a half day at 1:15 p.m. We return with Bonnie Rinaldi. Bonnie Rinaldi. All right. So, enjoy as I fade away into the background. Thank you so much for tuning in. Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine counties. All 17, not just 2 in the sportsbook, right? Yeah, we remember. Make sure to share this out. It does affect you. This is our water, the public's water, our natural resource. And this is a case right here that will set precedent in many cases moving forward. So let's hope the state prevails in this case and we do not have to pay for a developer and or companies who are out there developing natural resources in hopes of monopolizing our natural resources against us and billing us for the entirety of our lives, our children's lives, their children's lives. And maybe we'll actually get a fair shake at life one of these days. I don't know, but that's my goal, is to make sure that water, the public's resource, is not able to be sold at $20,000 an acre foot by companies like many of the different companies that Coyote Springs LLC is. That's why I'm here. That's why they call me the water boy. I'm Bobby Boucher, the water boy. H2O is better, especially when it's clean. It all started years ago, getting into this and understanding that I have people that are literally living in dirty water while we're talking about Flint, Michigan. I mean, think about it this way. In Nevada, how many people are actually drinking that water out of the tap? And then again, we're brushing our teeth and washing our bodies with it. And then here we are in amidst one of the serious and the most serious droughts and or dry seasons in Nevada's history. They're talking about Lake Mead every day. We're talking about water every day, developers, data centers, you name it. I think it's time we start taking an honest approach to what is really going on here. Thank you for joining me. You're watching W4Nevada Live. My name is Matt Winterhawk, and this is our continuing coverage, day 14 of Coyote Springs LLC versus the state of Nevada.
All right, part 13 is now accepted. I'll once again, glad.
Good afternoon, please be seated.
Your Honor.
Back on the record for non-jury trial in Coyote Springs Investment LLC versus State of Nevada, three state appearances of counsel and identified parties and party representatives who are present today.
Your Honor, Mark Hutchison and Rob Hernquist and Todd Kennedy on behalf of Coyote Springs Investments LLC and related plaintiff entities. And with us is the general counsel of those corporate entities, Ms. Amelia Cargill.
Good afternoon.
Good afternoon, I'm Jeff Sylvester and Matthew Neal of Sylvester Clinic on behalf of the state of Nevada.
Good afternoon. All right.
Your Honor, if I may,
I'm sorry.
pick up a quick couple of administrative matters. One is if you could just pop back up the screen for me on the Zoom. I'm pretty sure that Gary's iPhone is connected to Gary Woodard, who's our expert, but I just want to confirm that, Your Honor, if you wouldn't mind inquiring about Gary's iPhone.
Yes, who's appearing on Gary's iPhone on Zoom? The person's muted. Answer my, okay. Who is Gary on Gary's iPhone? Who? Thanks your name, you have to increase the volume.
I have a referral here.
Still can't hear you. Okay.
I don't know if you anticipate.
Not that she's on a phone call, but like the computer's on.
I think your computer may be muted, is that right? Is that what you said?
You know, that may be my father who probably doesn't know how to work his phone.
I'm sorry, what?
That may be my father who may not know how to work his phone.
What have I done?
Oh,
Who is it again?
Gary on Zoom, can you identify yourself, please? Gary, can you hear us, Gary?
I do text on my side. It's,
Yeah, we'll do the
I'm
same
not
thing.
sure.
It may be Gary Woodard, who's an expert, or maybe counsel's dad. Either way, we'll count. Can we just have Gary and see if that's him? Okay. So
Gary, who are you?
Oh, does it say the name at the bottom or just says iPhone?
Gary's iPhone.
okay.
Gary's iPhone, can you hear us? Everything else just.
I think so.
Okay.
That's mine.
What is your name? Oh, it's your.
I should say fine. Okay. No problem then. Gary's iPhone.
Very well.
Turn his mic back off.
You can mute yourself now,
I'll do it.
okay?
Thank you,
All right,
Your Honor.
Your
Sorry for the
So that was
delay.
the second, Your Honor, is just September trial dates. If we know anything more about that, we're just trying
We're
to.
gonna talk about that tomorrow.
Oh, we'll talk about that tomorrow. Okay, very well. That's all I needed, Your Honor. Thank you.
All right, the witness has retaken the stand. You realize that you're still under oath?
I do.
Okay, very well.
Ms. Rinaldi, yesterday afternoon, you kind of gave us an overview of the various steps or the first few steps of a master plan community. Fair?
Fair.
You talked about concept plans and the specific plans and development agreements.
Yes.
Okay. In that section of your report where you talk about master plan communities kind of as a whole, not specific to CSI, but as a whole, you titled that section, How Master Plan Communities Are Created dash an exercise in risk management, unquote. And I wanted to ask you about that. What did you mean by an exercise in risk management?
What I meant was from the very first of creating the process for reviewing master plan communities in Clark County, it was very clear that the process itself had to the process of risk management had to have various steps where each party could make presentations, get feedback at one level, and then only then take further steps, invest more money, invest more time, invest more other resources, and then get feedback on that work product. And after getting that feedback, take the next step. Every creation of a new community is complex, and especially when you're doing it inside the context of another community, or you need the approval and the feedback of that community to tie onto their services. There's just a lot of interaction and communication that has to go on, and just a lot of exchange of information in a timely way to get to the end result without anybody being surprised, in a way that is going to serve the public as well as meet the needs of the developer.
And the developer has some risk.
Absolutely. They spend a lot of time, effort, and money to take their vision and design it and engineer it and build it.
And the various government agencies that might be involved with that master plan community, they also have some risk.
I do. There's a lot of the public's resources that are spent, and there's always more demand for those resources than there are resources. And so there is risk in not getting other things done that might be of a different or even a higher priority to those that decide the priorities. So there's a risk on the amount of time spent. There's a risk in every step for a public agency is a risk in, not a risk, but it is an exercise in minimizing risk for the public, the future generations, the people that are going to live in those houses or drive on those streets.
And because of those risks, is transparency between the developers and the government agencies important?
Very, very important. You need transparency on the part of the developer to tell us everything you have in mind so that we can give you the proper feedback. And so you're not surprised later. We're not surprised later. If we're surprised later, it's still costs the developer, even though it's, if it's the public agency surprise, because they're going to have to stop, and developers don't want things to stop. There's a big risk in just in managing time and information. So transparency, knowing what the rules are, knowing what the timelines are that are associated with those rules, knowing what you have to submit and what you can expect coming out of that, is what the process is all about. I mean, everything from master plan communities to, getting a variance for your setback on your garage. It was always really clear and pounded into every public servant that transparency and predictability are the two essential things. Our job as public servants is to protect the public, but we also have customers who are also taxpayers and fee payers. And so our job there is to communicate what is needed and be professional and give the responses in a timely way and help everybody get out the door with what they expected, as long as they're meeting the rules and when they expected to.
And in that section of your report, you stated that, quote, that the steps, quote, must be taken in stages with government and property owners making a series of more detailed commitments to move forward step by step through a structured proposal and review process. What did you mean by that?
I meant that in general, there's a lot of information presented. You can't take big chunks of information and get the detailed feedback you need. You need to get very specific feedback. So in order to get specific feedback, you have to submit specific information, but sometimes you need other information before you can get more specific. So there's just a series of loops of getting more and more specific, getting feedback, and drilling down. And let me give maybe an example of, this is a simple example, but of transportation studies. You've got a new community. expected to have maybe 50,000 people. It's got residences, it's got commercial buildings, it may have a resort, it's got offices. Well, what kind of traffic is going to be generated? How is that going to impact the major infrastructure, like any freeways or major highways that serve it? So you get that general order of magnitude, but you don't have the details yet of how the villages might be laid out, how the streets and neighborhoods might be laid out. But you get enough information to start the analysis and kind of define the bucket that you're in. And then from there, you drill down further when there's more information available.
And in that portion of your report, you also write, quote, both landowners and local government risk is somewhat limited as they move forward one step at a time through the process. At each step, it is intended that there is enough information and assurances for both the landowner and local jurisdiction to make the investment necessary to move forward to the next step. Can you explain to us what you mean by that?
Yeah, I mean, maybe I'll use the same example of the traffic study. Only the information that's gathered from that master traffic study in terms of both what kind of trip generation there may be expected and in general terms, and what general impact that might have on highways and how the county, the state, whoever is involved might feel about that, or what their requirements might be. That information is then factored into the more specific study. And then the more specific study drills down with greater information. That gives you something like a village traffic study. And then there's even another deeper layer of traffic study. And all these layers of feedback inform the next the next submittal. It's next to impossible to start out with the detailed level of information. If it were possible, it would be extremely expensive, huge risk on the part of anybody to put in the time and effort necessary to direct their engineers on, this is exactly what we expect this village to look like and exactly where we expect the houses to be. And so you can do the trip generation models you need to do. If they provided all that, they would still just be guessing at that point in time, but they would have spent a lot of time and effort and money on something that may end up being irrelevant once they get some feedback. So it's a step-by-step process to drill down to get things right.
And you spoke earlier about how important transparency is. Is that transparency important throughout the process, each step along the way?
Absolutely, from both sides.
And
really are partners. I'm sorry.
No.
The proper relationship in a community, especially one that's grown as quickly and as with the magnitude that this community has grown. We, in the development review part of local government, we really are partners with the developers in a way. Our goal is to protect public interest, but we're partners with the community because we're all trying to build a wonderful community. And so transparency is just part of that partnership.
And that partnership, would that analogy apply to other government agencies other than the county level, like state agencies?
I would hope so.
And when we broke yesterday, you were talking about the 4 steps. You explained what a concept plan is, the specific plan and public facilities needs assessment, and we started talking about development agreements, I believe, when we broke, right?
Yes, we did.
Can you just briefly summarize what a development agreement is and why it's important in the process?
Yes. The development agreement basically, there's rules and regulations that give you a roadmap for how to file things and get your approvals. But then the development agreement is very specific to this project, this location, to a project and a location and a vision that's been conveyed through their planning efforts. And the development agreement spells out the commitments that the county's making. It's an agreement between the county and the developer. And it spells out the commitments that the county is making and the commitments that the developer is making to the county going forward. On the county's part, for instance, The developer is saying that they're going to agree to build X number of schools, X number of parks, this many acres at this point in time. They're gonna build a police station, a fire station, and at what point in time. And there's numerous other subjects, but that's the gist of it. On the developer side, they're getting a commitment from the county that this project, as specified in their plans that they've submitted to the county, is acceptable to the county, as long as they keep their commitments. And that the county is going to proceed to process their project. And the development agreement, one of the most essential parts of it, is that there's a lock-in of statutes not statutes, but county code that occurs. The developer specifies which codes they are they find important to them, and the county agrees to lock that code in for the future timeframe of the entire development agreement. So even if commissioners change, if public sentiment changes, if new neighbors move in next door, if other unforeseen circumstances occur, the developer has commitment that the county is going to proceed to let them develop under the codes that existed at that time. So, if the rules change and instead of every 100 feet, you have a street light, and the county says, no, we need them every 50 feet. In that development, under that development agreement, they can still proceed under the old rule of every 100 feet.
It's your understanding is that a development agreement is similar to an enforceable contract between the developer and the county?
Absolutely.
And the development agreement gets recorded?
It does.
Okay. And do you know whether there are any NRS provisions regarding development agreements?
Yes, the development agreements are authorized. Cities and counties are authorized to enter into development agreements under the state statutes.
And then in your report, the fourth and final step you discuss regarding master plan communities, you call it perfection of development rights.
Yes.
Can you explain what that is?
Yeah, so all of the approvals that a developer would have received from the county, including the development agreement, are conditional. I mean, even the development agreement itself spells out, these are the conditions, these are the expectations from the developer. And then the developer must, within the time frame that's been specified, must proceed to build the things they said they were going to build, to dedicate the acreage they said they were going to dedicate, to create the districts they said they were going to create. They have to keep their commitments. And so that is what perfects those entitlements. It's only after they've completed that at any particular phase that their rights are perfected on that property.
And as we move from the four different phases, right? Concept to the specific plan development agreement, and then the perfection of those rights. Do we see an increase, a decrease, stays the same as far as amount of work or cost from the developer side?
Wow. I'd say it really depends. It can depend on the scope of the development, but in the case of a master plan community, that fourth step, as I described in my report, is really where it's really largely about the performance of the developer, and they've got a ton of work to do. In the case of Coyote Springs, it was an exceptional amount of work because
we're going to talk about Coyote Springs in a moment.
Okay,
but we can just talk in general terms, and then we'll talk about Coyote Springs, if that's okay.
That's great.
So during that fourth phase, the developer typically is getting specialists like engineers and designers involved.
They are, yes.
Okay. And making dedications, public lands that were promised to the county or government agencies in the development agreement.
Yes.
Okay. Providing granting easements.
Yes. Mm-hmm.
And in your report, talking about, again, master plan communities in general and the steps, you describe it as, quote, an extensive, expensive, and involved process, end quote. Can you explain what you mean by that?
Yes, there are studies of so many different natures that are required, whether it's water, sewer, park systems, schools, so many different kinds of professionals that have to be brought, their expertise has to be brought to bear to design the community. So it's just a very broad and extensive number of people and those kind of resources that are involved, in addition to funds, land dedication, and funding to pay for all those studies and to have the plans designed, everything from general studies to plans for street improvements that spell out exactly where a water line is going to go. Just an extensive amount of information that has to be committed to. It's a huge exercise.
So let's turn now to the opinions that you discussed yesterday and that are discussed in the report. And I know you summarized it yesterday for us, but what is your opinion number one?
My opinion number one is that Coyote Springs complied with all the conditions of their development agreement, that they properly sought and received the approvals necessary to develop Coyote Springs, that they executed, they took the next steps and performed the studies and got the approvals necessary, and they began to build things and dedicate things and create things. So they received the approvals necessary, and then they began to execute all their commitments under those agreements.
And in your report under opinion one, you write, quote, Coyote Springs has made a substantial investment in time and resources to obtain and perfect their development rights, unquote. Is that statement consistent with what you just explained?
Yes.
So let's talk about that and your bases for that opinion. What's your understanding of the proposed Coyote Springs development as a whole? And let me interrupt you. Would it be helpful? I don't know if you have it all memorized, to have your report to reference here and there
Very
to
helpful.
refresh your recollection. Any objection, counsel? Okay. Clean copy here.
Since you have that.
May I coach you on? No.
Thank you.
Have all your notes.
So let's not put that on the record. No notes. It's a clean copy. You can look at it if you want.
So the question is, what is my understanding of Coyote Springs?
Yes, the proposed development as a whole. I think you begin your discussion in your report regarding opinion number one, talking about the project as a whole. So let's back up a little bit. Where did you gather or collect your information regarding this portion of your report? Where did you get this information?
So the information came for the report. It came most directly from my review of the county records. It also came somewhat from my own general knowledge, because Coyote Springs was something I was aware of, both in my roles as assistant county manager, as well as in the role I played in the private sector, coordinating a development in the Glendale area.
Okay.
Area.
And based on that various information, what's your understanding of the proposed Coyote Springs development project?
But it's a large community, that it spreads across 2 counties, that it includes over 40,000 acres, that it has 160,000 residential units, with about 50,000 of those being in Clark County and the rest proposed for Lincoln County. And then it's planned to be developed over a 40-year period of time.
And as far as the size of the proposed Coyote Springs project, how does that compare to, say, Summerlin?
Yeah, so it's almost twice the size of Summerlin.
Okay. And you mentioned both Lincoln County and Clark County.
Yes,
Actually, let me stop there. And what you described and what's contained there in your report, that's based on your review of the development plan and concept plan, other documents filed with county?
yes.
Okay. Can you explain to us your understanding of the development project in relation to Lincoln County?
Yeah, so there's just a world of difference between Clark County and Lincoln County, culturally, geographically, the amount of development that they're used to dealing with versus they in Lincoln County versus Clark County, a world of difference between the two, and different sets of regulations, and entirely different rules, different not only different rules, but different structures for how they review things and how their thought processes, and because they have different service providers than Clark County does. So it's even though it's just one step over a imaginary county line, there's a world of difference between the two. And it was my understanding that Coyote Springs was planning to focus their initial development and probably initial for quite some time in the Clark County area, and then eventually get to Lincoln County. Now, Coyote Springs, in my opinion, was smart and diligent to, even though they didn't expect to be developing in Lincoln County for quite a while, to approach Lincoln County, spell out what they intended to do or what what their vision was for Lincoln County, and receive approvals from Lincoln County. So Lincoln County did not have a process for really dealing with a development of this magnitude. And so they did some very generic things, but that left them a lot of control later on in the process. They did, am I going too far?
No.
They did what's, in my opinion, very generic, in that they adopted regulations that allowed them to do development agreements. They adopted something called a planned community district, which development agreements and planned community districts kind of fit together under the state statutes. But it basically says, we're going to set this, we recognize what you want to do. We're going to set this land aside, not set this land aside. We're going to consider this land differently. And we're saying that your project would be welcome here, but we don't have any information yet. And we don't know how we'll do any of this yet. And it's going to be up to you to pay for everything and figure it out. And we'll do that when it gets closer to the time. So they made it kind of a reservation, basically, with Lincoln County, and recorded that development agreement. So Lincoln County is on notice, basically. And Lincoln County has also said, we're accepting what your notion, and we're going to work with you to do it when the time comes.
And in your report, in the portion that discusses the proposed Coyote Springs development project in the Lincoln County site of the imaginary line, you discussed some various action items that were taken by Coyote Springs to sort of maybe solidify, my word, not yours, the future development. Can you describe what those are and why they're important?
Yes. I can describe what they are. I can't speak to their relative importance because I don't have a background in development in Lincoln County. So I don't know how important they are to Lincoln County, but they took further steps. They not only recorded the development agreement, but they started to create some of the districts and agreements that would be necessary for further development of a community. Do you want me to list those?
No, I think that's fair. And we'll get there in a moment, but you also took a look at the various steps that Coyote Springs took in Clark County. Agreed?
Oh, absolutely.
And could you give us your opinion, your view on comparing the actions that were taken on the Clark County side versus the actions on the Lincoln County side?
Oh, yes. On the Lincoln County side, they were all very general. They were setting up frameworks, and really broad frameworks for future action, future information. On the Clark County side, they were proceeding with actual development. Building a golf course, building a clubhouse, building roads.
And in your report, the most recent say, action item that you discuss related to Lincoln County, looks like it was around 2008. There's a document that was filed in 2005 and merged with something in 2010, but the Clark County activities, do they continue more recently?
Oh, they certainly do. They continue until 2020. And then there are some extensions of time after that, but the activity continued until 2020.
And you reviewed the records publicly available in Lincoln County for that portion of your report?
Did I review the records? I reviewed the record that these items were presented to the county or whatever district they need to be presented to. So a record of what they did as opposed to the exact studies that they submitted.
Okay, fair. Let's switch our focus then to Clark. Can you give us a general overview of your understanding of what the Coyote Springs Development Project, what the plan was in Clark County?
Yes, the plan was to develop their 13,000 acres there, or a lot of that is set aside for conservation area, but to begin development near the intersections of the two highways there, and to develop a golf course, and then proceed with residential development and all the things that are necessary to go along with residential development.
Okay. And when you were talking about master plan communities as a whole, you informed us that the first step is preparing and submitting a concept plan. Fair?
Mm-hmm.
Did Coyote Springs prepare and submit a concept plan?
Absolutely.
Okay, and is that something that was reviewed or approved by the Clark County?
Absolutely, extensively reviewed, and I was approved by Clark County.
Okay, and that's in the county's public records?
It is.
Okay. When was that concept plan approved by Clark County?
The concept plan was approved by Clark County in February of 2002.
And at that point in time, you were still in public service. Were you involved at all in the review or approval of the Coyote Springs concept plan?
I was not.
Okay. And then you explained.
I'm sorry. At that point in time, I was not in county service any longer.
So you certainly did not review
That's
or
right.
approve it. You
Mhm.
weren't personally involved
That's right.
there. And you explained that the next step is master plans, correct?
Yes,
Did Coyote Springs prepare and submit any master plans for its proposed development?
they certainly did. They submitted what's called a specific plan, which is basically a land use plan talking about development types, residential, commercial, et cetera, and densities. And then they submitted what's called a public facilities needs assessment that reviews the public facilities necessary to support the development that they're proposing in their specific plan.
And was that master plan approved by Clark County?
Yes, it was. They were approved in May and August of 2002.
Can you explain the May and August, which is which?
Yes, in May, the public facilities needs assessment was approved, and in August, the specific plan was approved.
And you explained that the third step in the process would be preparing and submitting a development agreement. Agreed?
Yes,
Okay, did Coyote Springs prepare and submit a development agreement?
they did.
And is that a document you reviewed?
It is.
And it appears in the county records?
It does.
And when was that approved?
That was approved in December of 2002.
Okay. And you explained to us yesterday that you were involved in the negotiation of the development agreement for Summerlin.
Yes,
Did I get that right?
yes, you did.
Okay. So the development agreement, is that a document that both sides author, or does the developer just write down whatever they want and ask the county to agree to it?
The county holds on to the authorship, to controlling the document. But it's developed in partnership with the developer.
Does the county have input on the language contained within the development agreement?
Oh, absolutely.
And are there situations where the county insists that certain language needs to be included in a development agreement for it to be approved?
Yes, you will find that, you'll find similar language in most of the development agreements that the county has approved because of exactly what you just spelled out. There are certain things that they insist be a part of every agreement.
Let's pull up Exhibit 8, please, Hunter. Is this a document that you recognize, Ms. Rinaldi?
It is the development agreement, including the First Amendment.
Okay, is this something that you reviewed while preparing your report?
Yes.
Okay. And let's turn first, Hunter, to Bates numbers 10. Look at that. Could you go up one page to 9? I'm sorry. Ms. Rinaldi, I'm going to represent to you that during this trial, language from this development agreement has been shown to witnesses, suggesting that the language in section 2.01F, titled Acknowledgement of Uncertainties, should have put Coyote Springs on notice that there was a risk regarding water. And that language is blown up for you there. Do you see that?
I do.
Have you seen this language before?
I have.
And accepting that my representation is true, would you agree with that argument?
I'm sorry, with which argument?
Would you agree with the premise that this language should have put Coyote Springs on notice that there are significant risks regarding its water rights or water permits?
You know, I can state unequivocally that this language is not specific to Coyote Springs.
Have you seen this exact same language previous?
Yes.
Can you explain?
Yeah, I think I might have written it in 1994. It's part of the Summerlin Agreement, the first one that the county ever entered into. And I know that it has been part of subsequent development agreements. I think it's part of every development agreement that the county has adopted.
So this language would appear in any development agreement reviewed and approved by Clark County since the Summerlin Development Agreement was first
Yes,
prepared?
absolutely.
Excuse me. And this section, it in general is called acknowledgement, or I'm sorry, can we back up, Hunter, just to the top of page 9? Right, the recital of premises, purpose, and intent, the recitals. Is that language in general, the recitals language, something that the county insists upon in every development agreement?
Yes, I think this is a template, basically. There may be some dates are changed, but this outline is followed for every development agreement.
Okay. And you testified a few minutes ago, you reviewed the Coyote Springs development agreement throughout, right? The entire document.
Yes,
And it appears similar, at least in some sections, to the development agreement for Summerlin
yes,
and many other developments you've seen over the course of your career.
yes, and many sections are very similar.
We can take that down. All right, thank you. Let's talk next then about the entitlement phase, the protection of rights, the fourth step that you discussed earlier.
Okay.
Did Coyote Springs take any actions to pursue the development and obtain those entitlements? I think you call it perfection of development rights. Did Coyote Springs make any steps to perfect its development rights?
They did. In reviewing this record, I found them to be exceptionally diligent. They did not waste any time submitting master traffic studies, for instance, or beginning to get the more specific entitlements necessary for pump stations, power transmission lines, some of that big backbone infrastructure that would be required for their community.
Okay, and my understanding is that fourth step, a lot of it would be connecting the proposed development to existing infrastructures that might exist in the community. Is that accurate or fair?
Typically, yes.
Okay. And you say typically, was Coyote Springs different?
Yes, in that they had not much to connect to. And they had no water district, no water purveyor, nobody to provide and treat their water, nobody to collect the wastewater. They had to, there was very limited, there were no schools out there, very limited police service, very limited fire service. So they had to create all these systems, not only connect to them, which is, an effort in and of itself to do the design necessary and get the and the construction necessary to do the connections, but they had to create the systems. They had to create that backbone themselves.
And based upon your review of the county records, was Coyote Springs diligent in creating that backbone, your words?
Yes, very much so.
In your opinion, did Coyote Springs fund and complete significant actions to meet its obligations under the development agreement?
Absolutely. Every one of these things on my list are really the.
Let me stop you there. Let's get that list in front of everyone and try to follow the rules of evidence, and we can talk about it. Fair?
Do you not? I'm glad not to go there yet either.
No, you're fine. You're fine. If we can, Hunter, can we pull up Exhibit 553? And before we discuss the substance of any of this, Ms. Rinaldi, can you explain to us, let me back up. Do you recognize this document?
I do. It's part of my report.
I'm sorry, it's part of your report?
Yes,
Did you prepare this on your own?
I did.
And can you tell us how you went about preparing it, including the information that you relied upon?
Yes. I prepared this myself, and I prepared it from my examination of the full county record on the land development for Coyote Springs. And then the information about the water rights, which go hand in hand. Certainly they do in this, in my assignment in this case, because it has to do with water rights, but land rights and water rights always go hand in hand because you have to bring both together to do any development project. But it was important to me to be able to see the connections between, how far along they were on their land development and how on perfecting land rights as well as perfecting the water rights and how those coincided with each other. But most of that information on the water rights column came from citations in various legal filings in the past.
Okay, so if I understand you correctly, the column entitled Land Development Rights, those are summaries of documents that appear in the Clark County Public Records?
Yes.
Okay. And then the column on the right, the water rights, those for the most part are summaries of information that you gleaned from court filings?
Yes.
Okay, and let's turn them to page number 4, Hunter. 553-4 or Rinaldi Miller. Right. So one last question on the structure of this, Ms. Rinaldi. You can see there's a line entry for 2007 October. Do you see that recorded map of 30 Builders Lot?
I do.
Okay, and you have some information though on the right side under the water rights column. Do you see that?
Yes.
So if there's type in the land development rights column and then language also appearing under the water rights, that's your summary of a document that appears in the county records?
Yes.
Okay, and then a couple lines down, we see 2008 and there's a blank box under land development rights. You see that?
Yes.
But then there's some text on the right column about CSI pumping.
Yes.
Okay, so that would be an instance of information you gleaned from court filings?
Yes.
Okay. Your Honor, we offer Exhibit 553 as a summary under NRS 52.275 with a caveat that if there's a summary, Ms. Rinaldi's summary on the water rights column, but it's a blank box under the land development rights column. We would not be offering those for the truth.
I don't have an objection to using this document for witness.
What's that?
I have no objection.
Yeah, admitted.
So backing up again, if we could go to page 100, please. Just want to kind of go over this document with you, Ms. Rinaldi. We're not going to go through it line by line by line, but I want to get a sense of the significance of this to you. We see a line item for 2002 February, Coyote Springs concept plan. Do you see that?
I do.
That's the document that you discussed earlier,
Yes, it is.
and you reviewed that here. And it appears in the county records, correct?
Correct.
And then a couple lines down, 2002 May, we see Coyote Springs Public Facility Needs Assessment approved. Do you see that?
I do.
You spoke about that earlier,
Yes,
and that document appears in the county records.
it does.
And then we go down a little further, Coyote Springs Development Agreement and Zone Changes to PC approved. Do you see that?
Yes.
What is that?
That's the date that Clark County approved not only the development agreement for Coyote Springs, but the zone change to planned community. That was
Okay.
to kind of go hand in hand.
And then immediately below that entry, you have a header and it says actions to comply with and perfect the development agreement. Do you see that?
I do.
Can you tell us what that means?
Yes, so I was distinguishing between the earlier list, that those were all the things necessary to obtain the development agreement. That was all the steps to present the vision, get approval of the vision. And then the actions below this line are complying with the development agreement. That's where so above the line is obtaining the entitlements, and below the line is perfecting the entitlements, executing the steps necessary to perfect the entitlements.
Everything under that line is Coyote Springs pursuing step number 4 that you explained to us a few minutes ago.
Yes,
Okay. So for instance, on this first page here, we see a couple of use permits, master park facilities plan, things of that nature.
yes, and every single line here, it has an action where the county took formal action. Now, behind every one of those is lots and lots of hours and meetings and studies and design effort. So this one little line represents a whole lot of effort, each and every line,
And a whole lot of effort for the county, the developer, or both.
both. In some cases, it's mostly on the part of the developer. In other cases, there was a lot of meetings with the county in order to get to that point.
So let's turn then to the next page. And if you would, Ms. Rinaldi, maybe just summarize this or walk through, we see all these action items on the second page. What do these action items tell us?
Well, they tell me that Coyote Springs was moving forward in a logical step-by-step way to get the approvals and start construction of their golf course, their first subdivision, all the studies necessary to accompany those, like hydrology studies, addressing systems, fire protection facilities, a use permit for a park. They were moving forward in a comprehensive way to build their community.
And if we scroll down about a third of the way down on the page, we see an entry for 2005 October regarding a tentative map. Do you see that?
I do.
And you have notes in there saying that the state engineer recommended disapproval. Do you see that?
I do.
Is this a document that you reviewed?
It is.
And that language you wrote here, state engineer recommended disapproval, did that concern you?
No, I would have expected it at this point in time. I mean, I expected first that the state engineer would be getting on the record that water hasn't been worked out yet for this tentative map. However, that's the case with, well, let's see, at the tentative map stage, it's again, subdivisions are done in steps, just like all the other things we've talked about. A tentative map is submitted and it outlines the developer's layout for a neighborhood. And it has enough information on it to let all the utility providers, the county road builders, to let the county planning department to review the lot sizes. It gives them that general information, and then they provide feedback. There's another step called a final map where the developer is expected to have taken all that feedback into consideration and gotten more precise. And not only do they get more precise, but they usually get smaller. They're not ready to build. The tentative map is often big in terms of the land it covers, and final maps are usually done in as a phase of that tentative map, but then they get much more specific. So the issues about water are rarely worked out at a tentative map stage. Even if we were in the Las Vegas Valley Water District service area, they haven't designed their water lines. They don't know how big they need to be. They don't know what pumping stations are needed yet at a tentative map stage. It's an information exchange stage.
And at this point in time, to your knowledge, was there a water purveyor that had been identified yet for the Coyote Springs proposed development?
No, at this point in time, I know in the specific plan and the concept plan, there's quite a bit of discussion of Coyote Springs working with Moapa Valley Water District to be their water purveyor. I know that Moapa Valley Water District, that changed at some point in time. I don't know exactly the point in time, but the issues of who the water purveyor would be hadn't been resolved yet.
And could that be a reason why the state engineer recommended disapproval at that time?
Yes.
And to your knowledge, had the GID been entered into yet?
I don't think so. I'd have to look and see the dates, but it looks like the GID was created in 2006.
And the creation of the GID, would that be relevant to approval of water?
It'd be the first step in approval of water. I mean, that just creates an organization, but it'd have to get water in their tank.
And again, though, based on your nearly 30 years working for the county and various cities within Clark County, this entry here, the state engineer recommending disapproval, that's not a red flag or concern to you?
No, it's just putting everybody on notice.
Notice of?
Notice that issues with water availability need to be worked out.
Availability or deliverability or something else?
From the state engineer, it's more about availability than deliverability.
And the development agreement does contain information in it regarding the water permits that Coyote Springs held, correct?
I think it did list them.
Okay. And in a development agreement, even if the developer identifies the water permits they hold, it would not be uncommon for the state engineer to still recommend disapproval for various concerns.
Correct. The state engineer, from my observation of my years of observing, does not recommend approval until they know that the quantity of water is available at the water purveyor. And so they generally, when you're talking about a residential subdivision, not a builder's lot map, but a residential subdivision lot map, they are really looking for feedback from the water purveyor that, yes, I have this water and I can deliver it.
Let's turn to page 3. Rinaldi 8. And again, this Rinaldi is kind of, if you just skim over this and explain kind of big picture what these line items tell us.
The line items on this page there's quite a bit in regard to tentative maps that were submitted, as well as being annexed into the multi-species habitat plan conservation area or conservation plan. Another thing that most developers don't have to do because Coyote Springs was not within the area addressed by the existing multi-species habitat conservation plan, so they had to be annexed into it. Submitted various traffic studies. Oh, they submitted an application to the BLM to build a 325 acre flood control detention base. Pretty significant infrastructure. Use permit for treating effluent storage, basically the beginning of their wastewater treatment plant for the community. Water system master plan approved by the Las Vegas Valley Water District. And the rest are tentative maps, all
Okay, and then page 4. Okay, we see here line items, July of 2007 through 2013, where Coyote Springs is still pursuing its development rights.
absolutely, yes, that's taking further steps.
Okay. And page 5. Some zone changes and tentative maps.
Yes,
And page 6.
page 6 has mostly to do on the land development side with mapping.
I'm sorry?
On page 6, and all have to do with mapping, subdivision maps.
And then following your chart, you list some additional studies and permits that were prepared by Coyote Springs and approved in Clark County. Do you see that?
I do.
So you first subject line drainage studies.
Mhm.
And you spoke earlier, you said that each of the line items that we see in the chart, a lot of hours, a lot of time, a lot of expense to get those documents prepared and submitted to government officials. I heard you right?
That's right.
Would the same be true for the drainage studies?
Absolutely.
Would the same, go ahead.
Every one of them, each one of them. Yes.
The traffic studies,
Yes.
the land development entitlements?
I'm not sure what you're speaking of with the land development entitlements.
It's at the bottom of page 6, or page 11 of your report. Land development entitlements, and then it carries over to the other side. Miscellaneous variances and waivers
Oh,
of
I
development
see.
standards.
I see. Yes. Yeah. I didn't list all the little itty bitty things, or at least that I would consider about waivers of development standards. I listed, my chart listed all the major actions necessary, but for each one, for each, let's just say, for instance, for a let's take one of the use permits. I'm just going to use it as an example, not that it really relates, but I'm just as an example. Well, for excuse me, any one of these maps, which really represents how a neighborhood's going to be laid out, they may have needed some changes to the development standards, meaning maybe narrower street widths were proposed because of a specific design that they wanted to incorporate. Maybe they had higher fence heights to deal with various grade issues, but that's what that paragraph is about all the smaller, more detailed requests that may have been made to the county to waive or vary the rules to fit the vision that Coyote Springs had for their community. And then there are, of course, extensions of time and other things, but they aren't the major steps involved with perfecting their development rights. They're more minor.
And then the next section, you have street improvement plans and bonds.
Yes, so every one of those street improvement plans requires a significant engineering and design. They're designing not only the street width and the depth of the pavement and but where the water line's going to go, where the cable lines are going to go, where the sewer line's going to go, making sure all the grades fit, and then they have to bond for those improvements before they can record a map.
And then the next section, building permits, same question, a lot of time, a lot of expense.
Absolutely, yeah. They're getting into the particulars of construction. you know, how thick the walls are, how tall they are, what materials they're made of, whether they have the right structural design.
And in your report, you say that not only did CSI invest millions to prepare and process approval studies and plans, but they also granted exactions to enable them to continue the development. Can you explain what that means?
Yes, in the development agreement, the county required Coyote Springs to dedicate certain things, navigation easements, for instance. They beyond the development agreement, the county code requires dedication of certain things. And so in this case, Coyote Springs had to design and construct a flood control facility of over 300 acres. They designed and constructed a wastewater treatment plant. They designed and constructed groundwater production wells, two of which were built to municipal culinary standards, but they also just granted acreage.
And let me stop you there. The flood control facility, the wastewater treatment plant, the wells, are those items that the state engineer would have been made aware of?
I believe so. In some cases, I know for fact because I saw their approvals on permits related to those facilities, and others that I just know in the process, they are part of that process.
And the chart that we looked at, Exhibit 553, all the various filings that were submitted to Clark County, would any of those documents been provided to the state engineer's office?
Yes, it's the county's practice to, when land use applications are submitted at their front counter, to distribute those and information about those to a number of departments and agencies, including the State Division of Water Resources.
And I interrupted you. I apologize. I believe you're also talking about dedications.
Yes, Coyote Springs gave up their land for a wastewater treatment facility. They granted easements for perpetual navigation. They constructed and dedicated streets and storm drains, water lines to the general improvement district, constructed and dedicated sewer lines. Those are dedicated to the water reclamation district. They constructed and dedicated power lines to the power district and constructed a 3-megawatt power substation.
So based on your review of the Clark County records, is Coyote Springs in full compliance with its development plan?
Yes, absolutely.
Have you ever visited or toured the Coyote Springs site?
I have.
And when was that?
I toured it in May of 2023. And I had visited it on other occasions as well. Sometimes on occasion or two prior to any development and after. But those were just kind of drive-bys out of general curiosity about what was going on out there, but also because I was involved with the project that was a few miles down the street, and what they were doing may have impacted what we were doing. But the tour in 2023, I toured many of the streets and drove around with Bill Coulthard and Amelia Cargill, and was amazed by the magnitude of the development there. I mean, I knew that there was a golf course. It was kind of general knowledge, but seeing the streets that were paved, seeing the stormwater systems, I mean, the fire hydrants that are sitting there waiting to be used. It was incredible to me. The only thing missing are the houses.
Hunter, can we pull up Exhibit 296? 296. And if you would, maybe just slowly scroll through the pages. Ms. Rinaldi, do you recognize these photographs?
I do.
Can you tell us what they are?
They were photographs that either I took or Bill Coulthard took during the tour in May.
May of 2023?
Yes.
Okay. And as we go through these photos, so these photos fairly inaccurately depict the scene at Coyote Springs on the date of that tour, May of 2023.
They do, except the photos really can't convey the magnitude of it all because they're all individual shots. But to stand out there and see what was built is just, it was overwhelming to me.
And I appreciate that a photo maybe can't often show us the magnitude, but these photos, this is what it appeared to you at the time. Nothing's been altered.
Correct.
Okay, we offer 296.
No objection.
Admitted.
And we see there in the bottom photograph, one of the fire hydrants you mentioned, right?
Yes. Mhm. And the storm drain, I mean, it's waiting to drain water from a street that isn't there yet. But it's ready. Which means, you know, that it was designed, you know, a design was made for the stormwater systems here, and they know how much water is supposed to go through. There's been just a lot of detailed work that was stopped in its tracks, basically, because you usually don't see these things without the accompanying streets next to them.
And during your nearly 30 years of public service, I assume there was other instances where you went out and toured or took a look at master plan communities that were in progress, fair?
Yes.
Do you have any opinions regarding the infrastructure at Coyote Springs, maybe compared to past experiences?
Opinions about it. Let's see, just how extensive it is and how it exists without what usually accompanies it. It maybe reminded me of, I don't know if you remember the days when things stopped in Laughlin and we saw buildings half built and then just walked away from. It was like a bit of a ghost town.
But significant infrastructure, fair?
Absolutely significant.
Over the course of your government career, have you worked with a lot of developers?
I have.
Okay. And based on your review of the public records relating to Coyote Springs, how does Coyote Springs compare to other developers on issues such as diligence?
Well, I was very impressed with Coyote Springs' effort and how comprehensive it was right from the beginning. It seemed to me that they didn't wait to be told that you need to work this out with this agency and that out with that another agency. They were appeared to be very aware of the context in which they were proposing to do a development, and they initiated the relationships to begin to make way for their development. So they took the initiative, they followed through. I don't see any evidence of cutting corners. Like, I mean, every aspect of this requires a lot of time and money. And it's only normal that a developer would try to find an easier way around. I see no evidence of that with Coyote Springs. They took the high road and followed through.
And during the course of your government career, did you encounter situations where a developer maybe tried to cut corners or shortcut or push things a bit with government?
Of course.
And you don't see any of that here as far as Coyote Springs goes?
I don't.
During your career in government, did you encounter situations where the developer didn't have the resources to bring the concept to reality?
Yes. There's a lot of speculation in the land development business. There's no evidence of speculation here.
That was my next question.
You can see how well, for instance, concept plan, the master plans and the development agreement, because each step informs the next one. It's typical that a developer would wait for the response on one before they start the effort on the next one. That didn't happen with Coyote Springs. They were ready. They amassed their team and began their work on the next application before they had the first one finished.
And based on the materials that you've reviewed, the various filings with the county, does it appear to you that CSI had the financial wherewithal to go forward with the development?
Yeah, it certainly did. I mean, there's no evidence of lack of wherewithal.
And this came up at your deposition. Did this appear to you to be a fly-by-night project or a pipe dream?
Absolutely not. I mean, it's, the project itself is amazing in its magnitude. What is equally amazing, maybe even more, is Coyote Springs' commitment or interest in bringing it to fruition. They move forward diligently and quickly to make this a reality.
And my next question, I'm not asking you to give an estimate as to total dollars or anything like that, but compared to other master plan communities, was this a large investment or a significant investment?
Yeah, it really is. I mean, the fact that they have to create the backbone infrastructure themselves makes it a hugely different order of magnitude than even Summerlin was, or Rhodes Ranch, or Southern Highlands.
Lots of paperwork and applications.
Lots of that, but lots of engineering studies and lots of design work and lots of commitment of dollars and time and energy, resources of all types.
Construction.
Oh, and definitely when it comes to construction.
And all of those steps require bringing in specialists, right? Engineers or contractors or lawyers or whatever it may be.
All of the above, yes,
Those people all cost money
they do.
and it takes time.
Yes.
And here, did you see anything that CSI didn't do? Was you went through the county records like, oh, they kind of messed up here or there?
No, in fact, and as I focused, or I was most driven by the land development side of things and the order and what was done and when. But then when I saw some of the other related issues, water being one of them, I mean, they were already working on the multi-species habitat conservation plan amendment. They didn't wait to be told to do that. They were already working on issues with the Muddy River and before they were told to do it. I think I got off track. I'm forgetting.
No, you're good. You're good. Let's talk about that a bit. So you mentioned the GID earlier. Do you have any opinions as far as how Coyote Springs approached water issues by creating or forming the GID? Was CSI diligent? Did it have the right players involved? What are your opinions on that?
Yeah, I have, that's not something I would have normally been a part of in my work with the county. But in my work with the private sector, the developers or the property owners I represented also had water rights that needed to be, some were surface rights, some were groundwater rights, and they needed to be perfected. They needed to be delivered to some kind of water purveyor, because developers usually aren't in the water treatment and water delivery business and don't want to be. So they need a partner to do that. And it was very clear that early on they were working with Moapa Valley Water District, who is the closest one to the Coyote Springs land. And then that transitioned at some point. I'm not sure all of the reasons why, but they moved forward to create the General Improvement District.
And over the course of your career, have you ever seen another developer invest this much toward the development of its water rights?
Objection foundation, he hasn't established how much they invested.
Sustained.
Investment of time and resources, not dollars. Fair objection.
I don't know of any other land community that had to create this much of its own backbone infrastructure and either create or bring along the various service areas. So the amount of investment of time and effort to create that backbone infrastructure was significantly larger on the part of Coyote Springs.
Okay. And just wrapping up opinion one then, with everything we've discussed, can you again just kind of explain to us with what we've talked about this afternoon, your opinion one?
Yes, my My opinion one is that they pursued their entitlements and that they have followed all the steps necessary to perfect those entitlements to date, and that those entitlements are in place and current. And further, that it took a huge investment of time and effort and money to get to this point.
Okay. Let's move now to your opinion two. And I know you summarized that for us yesterday, but could you tell us again, what's opinion two?
Opinion two is that they also fulfilled, not only they fulfilled all the conditions for their development agreement to date, but all the conditions necessary for subdivision mapping for Village A. The two maps in particular, Village A, Parcel A-B, and Unit 1, including submitting a report demonstrating a verifiable source of water, and that those 2018 subdivision maps, now these maps were done twice, but the first effort, 2018 maps, should have been approved by the state engineer in a timely manner, and that would have allowed the maps to be recorded, which would have allowed development to proceed in Coyote Springs.
I want to get into your bases for that, but first let's back up. And you mentioned this earlier. Can you explain the difference to the core difference between a tentative map and a final map?
Yes. A tentative map presents some more generalized information. It lays out roadways, it lays out lots. It lays out the intent for the subdivision, but it doesn't have all the details of the design ironed out at that point in time. And it is an opportunity. It provides an opportunity for all of the service providers, whether they're the county reviewing road plan designs or water lines, sewer lines, power lines, the zoning. It allows everybody to give their feedback on the proposal that is then intended to be incorporated into a final map. Now, final maps then are submitted, and at that point, much has been designed in a very detailed manner. So a tentative map is usually a much broader in scope in terms of size and amount of land included. And then because, again, this elephant, even that size of an elephant, can't be undertaken all at once, the developer will submit a final map for just a portion of that tentative map. A very logical progression of a series of maps usually follow the tentative map, and each one of those final maps then would complete that tentative. But at the final map stage, that's where the developer also has to present for approval and review and approval. There's very specific plans for water distribution lines, for wastewater collection lines, for their power lines, for their roadway network, and then each of those plans. So county acts as a coordinator for those maps, but each of those separate plans has to be reviewed by the appropriate agency, and then the appropriate agency has to sign off on a final map before it can be recorded.
Thank you. And can you explain the difference between large lot maps and subdivision maps, and
Yes.
why each is necessary or what the purpose is of each?
Yes. With a project as big as a master plan community, even just a tentative map is too much detail. They usually start with a large lot map, sometimes called a builder's lot map, that breaks the project up into not the final subdivision lot, that you would build a house on, but the reason they're called builder's lots is because they might be 10 acres in size, and then that land might be sold to a builder, and the ultimate house builder would then finalize that plan and present a tentative map on that builder's lot ultimately. So a builder's lot is just an initial phase where the land is subdivided into large parcels. The thing with mapping is that the county and the state and every agency that signs off is saying that this land, this new lot that you're creating, you're starting out with, let's say, 100 acres, and now you're going to a 10-acre lot and 10-acre lots now. Each one of those with the design that you've submitted and we've approved, we can provide service to. There's a road to get to it. It's big enough to meet the zoning code. It's big enough to support a well and or septic tank. So each one of these will be a legal lot permanently and forever. And the builder's lots are created, but they're really just like, they're just like a one big housing lot. Like the only thing you could really do on that builder's lot ultimately is build one house on that piece of land.
And in your report, you
But I'm sorry, let me finish it. But
Please.
it's real clear when it's called a large lot map or builder's lot map, it's real clear that the intention is to further, to do more with that, to further subdivide it at some point in time.
Thank you. And in your report, you talk about how CSI submitted 2 tentative maps in May and June of 2018, one a large lot, and then the other for 575 single-family homes. Fair?
Fair.
Hunter, can we pull up exhibits 203 and 204? Ms. Rinaldi, do you recognize these documents?
I recognize the forms and yes, I've reviewed these documents.
Okay. And I just want to ensure that we're on the same page. These are the tentative maps referenced in your report?
Yes, they are. I'm looking to see if this is the 2018 submittal or the 2022 submittal. I'm not seeing dates right off the top of my head.
We're going to scroll the second page if it's helpful.
Looks like they're 2018.
And in your report, you state that those 2 maps were approved by Clark County, fair?
Yes, those tentative maps, yes.
Okay. And just as an example, can we pull up exhibit 89, Hunter? Is this one of those approvals you reference in your report?
It is.
Okay. And would the state engineer review tentative maps? Actually, let me back up a little bit. Would tentative maps be provided to the state engineer?
Yes, they are definitely provided to the State Division of Water Resources.
Okay, and are there any NRS provisions that require tentative maps to be provided to the state engineer?
Yes, that's one of the reasons the county does it. It's required under the state statutes and under the statutes, the state engineer or the Division of Water Resources is required, among other agencies, to submit their comments within 15 days.
Are they required to provide comments?
Yes, under the statutes.
And Hunter, can we pull up that slide we discussed yesterday, NRS 278.335? Ms. Rinaldi, I'm showing you an NRS provision. Are you familiar with NRS 278.335?
Yes,
Okay, and as your understanding that this provision requires tentative maps to be provided to the state engineer, right?
yes, it does. It says to the revision of water resources.
And that's section 1A.
It is.
Okay. And then subsection 5. I believe that's the language you referenced a moment ago.
That each reviewing agency shall, within 15 days after receipt of the tentative map, file its written comments with the planning commission or governing body.
And based on your review, and who would the reviewing agency file those written comments with?
They file them with the planning department on a tentative map.
Okay, so if the tentative map was submitted to Clark County, they would submit their comments to Clark County?
Yes.
Okay. And based on your review of the Clark County records relating to Coyote Springs, did the state engineer respond within those 15-day window to any of the tentative maps?
They did respond to some early in the process in 2005 and 6, but not on the 2 maps we were just talking about.
Okay.
And not on most of the rest.
Okay. So at a certain point, the state engineer was no longer complying with NRS 278.335?
That'd be my conclusion. Yes.
And if the state engineer had provided its written comments as required by the statute. Would those written comments, there be some record of those in the county records that you reviewed?
Yes,
The county logs or makes a note that those comments were received?
what they do is they actually include the letter or the comments. Sometimes it's letter form, sometimes it's on a format, a template, but those are part of the record.
And you saw no record of any comments from the state engineer regarding these 2018 tentative maps that we just looked at?
Correct.
Okay. Pull that down, Hunter. Thank you. Let's next pull up exhibits 116 and 205. 116 and 205. Yes, thank you for the clarification. Ms. Rinaldi, have you seen these documents before? We can maybe scroll to the second page to provide some context of what these are. I'm going to represent to you that these are conditional approvals sent by the state engineer on September 8th of 2018. That helps you familiarize yourself with them.
Sent to whom? Sorry, so many of these letters are similar format, so I have to drill down into the details to respond.
These are, let me back up a little bit. Your report on the bottom of page 13 discusses the state engineer issuing conditional approval letters. Agreed?
Yes,
Okay. And you reviewed those conditional approval letters? When preparing your report?
I did.
Okay. And if we could scroll, Hunter, to the final page of each.
I see now. Yes, now I'm recognizing.
Okay. And they've been referenced by the state in this litigation as conditional approvals. My question to you, after your years of public service, are these approval letters?
No,
Why not?
so these are on tentative maps, correct?
Yes.
You know, on a tentative map, it's not a surprise that we'd get that kind of a letter on a tentative, that the county would get that kind of letter on a tentative map because, you know, that's the initial map. And oftentimes there always are other things that need to be done, designed, built, whatever, to, before a final map could be recorded.
But you're in your opinion, reviewing these are not approvals?
These are not approvals. Well, the context of that question is different in that, it's a conditional approval, again, not out of context for a tentative map, but not enough to go forward with a recording of a final map. And can I review this letter again? Just, I haven't looked at this in a long time. Can I review it in total?
Yeah.
Looks like they may be identical.
They relate to each of the two maps, but otherwise I would agree with that.
And the next page, please. And the next page, please. And the next page. Um, these letters lay out the conditions upon which the tentative map, a final map could be recorded. That is the subject of part of this tentative map. One thing I don't understand or haven't understood is why the state engineer said that a will serve letter from a water purveyor is required on the large lot builder's map, because with those maps, there's no water lines. Or those are very large lots. There's not even, there's no, typically not a water purveyor that provides water. Those lots are typically large enough to support a well. And so typically, and with all the previous large lot maps recorded in Coyote Springs, the state engineer provides the water commitment in terms of usually it's 2 acre feet per lot. So I'm not sure why they were involving a water purveyor on the large lot map. But as to your question about are these approvals, well, they're conditional approvals.
Well, that's what it says, but is anything really being approved here from, based on your years in government?
Oh, approved? No, they're supposed to be put on notice.
We can take those down, Hunter, thank you. And then your report, you talk about after those conditional approval letters came out, the draft order that was issued by the state engineer in the fall of 2018, and you talk about then Order 1303. And you say your words, declared a temporary moratorium, but there was language maps could be approved if a developer showed sufficient supply of water. Are you with me?
I am.
Okay. And then your report states that in June of 2019, CSI submitted Mylar for its final map, along with a technical report showing a sufficient supply of water. Right, that's laid out in your opinions?
Yes.
Okay, and can we take a look at Exhibit 7600? Again, Mr. Rinaldi, just take a look at this document. I just want to ensure that we're talking about same documents. Is this the June 13th, 2019 submittal referenced in your report?
Yes.
And then your report states that the state engineer, and actually, let me back up a little. This is submitted June 13th, 2019. Do you see that?
I do.
Okay. And then your report outlines that the state engineer denied those maps on June 17th of 2020. Could we pull up Exhibit 57, please? Just scroll to page 2, please.
Just want to make clear that when you're referring to these exhibits, these are admitted exhibits.
These are all admitted already. Yes, Your Honor. I've moved for admission for the couple that weren't already in. But,
That 203 and 204.
Those are,
Yeah.
553 and 296.
I'm sorry, what?
553 and 296 were admitted today.
correct. And everything else should already be in.
Okay, thanks.
No, thank you, Your Honor. Great question. So, Ms. Rinaldi, we're looking at what's been previously been admitted as Exhibit 57, dated June 17th, 2020. Do you see that?
I do.
And is this the denial that's discussed in your report?
May I see the second page?
Sure.
Yes.
So first question I have for you, we saw that Mylar was submitted June 13th of 2019, and we have this denial June 17th of 2020, right? So over a 1 year period, is a delay like that normal?
Not in this step of the process, no.
Is a delay like that concerning to you?
It definitely is.
Why?
It means that people aren't communicating. It means that the state took no action for 12 months. They were required to approve or deny, and they did nothing for 12 months. And then again, in this case of this particular map, the large lot map, they're asking for a will serve when a will serve isn't required. And they're asking for a will serve. The will serve can't be granted until the water district gets their answer from the state. So they're in a catch-22. The developer's in a catch-22.
Catch-22 meaning there's no way for them to work their way or plan or get past this without cooperation of government agencies?
Correct. The water district can't issue a will serve until the state answers their question about water quantity, and the state's not answering the question about water quantity, but asking for a will serve. So they're pointing at each other and not providing any answers.
And in your report, you talk about how CSI's June 13th, 2019 submittal with the Mylar, the final map, it also contained a technical report prepared by a company called Stetson Engineering, where CSI attempted to show that there was a sufficient supply of water and that it had met the requirements of Order 1303. Those are your opinions, fair?
Yes, that was submitted. My opinion is that it was submitted. Yes.
Okay. And to your knowledge, did the state engineer ever respond to the technical report provided by CSI that was prepared by Stetson?
I've seen no evidence that they ever replied about the report, approving it, denying it, asking any questions about it. There's no evidence.
And is that odd to you? The state engineer's failure to reply to the Stetson report or ask questions or seek follow-up or seek clarification? Silence, is that odd?
The silence is very odd. I would have expected there to be a paper trail of questions about, questioning it. If they didn't find the report to be satisfactory, there should have been communication about what parts weren't satisfactory and where more information might be needed. But there's not even reference to that report in this denial. I don't recall that, but just that it is, there's not enough water.
Exhibit 57, right? Doesn't discuss the Stetson report at all.
Can we see the second page again? I want to make sure I haven't overlooked something. I don't see any evidence of any discussion of that report, with the exception that on the first page there was the engineer Stetson Engineers. Now, yeah.
Now, we looked earlier about an NRS provision that requires state agencies to respond with comments, if any, to a tentative map within 15 days. Recall that?
Yes.
Is there any legal or statutory requirement in Nevada on how quickly the state engineer was required to respond to a final map?
There is not.
Okay. And your report says otherwise, right?
It does.
Can you explain?
Yes. First of all, I want to say that in my initial report, I did not mention anything about the Nevada Administrative Code or deadline on the part of the Division of Water Resources for final maps. But as I reviewed my report over the intervening years, I thought I found some additional evidence. So my point is that it didn't affect my opinion. My opinions have not changed, but in the Nevada Administrative Code that corresponds with the statutes about the state engineer's office and other agencies responding to the review of tentative maps, to the review of maps, the Nevada Administrative Code talks about the division must respond within 30 days. Well, I made the inappropriate assumption that the division they were speaking of was the Division of Water Resources. In fact, it's the Division of Environmental Protection.
Okay, so we have a statutory requirement, 15 days for tentative maps. No statutory requirement for final maps.
Right.
Fair. And an error made in the report,
That's right.
you're owning that error.
And it doesn't affect my opinions. Yes.
Okay.
It is an error.
And notwithstanding that maybe there's not a statutory requirement, during the course of your career working in government, is there an expectation that state agencies like the state engineer are going to be diligent and respond to final maps in a fairly professional and quick manner?
Yes, there's an expectation that all public agencies would be responding in a professional and timely manner.
Okay. And in your opinion, was the state engineer diligent in its dealings with CSI's maps?
It does not appear that way from the record.
And that's based on your review of the county records?
That's based on my review of the county record and my experience with other projects.
And in your opinion, was the state engineer transparent in its dealings with CSI?
It does not appear so from the records that I reviewed.
And in your opinion, was the state engineer acting in good faith in its dealings with CSI?
It does not appear so in my opinion because of the finger pointing I mentioned earlier, where the state is putting responsibility on the GID. The GID needs answers from the state before they can act. So I don't believe they were acting in good faith.
In your report, bottom of page 14, you write that, quote, beginning in 2000, if not earlier, the state of Nevada Division of Water Resources was aware of the proposed Coyote Springs planned community and the intent to build and sell homes in the community. What is that based on? How do you know that the state engineer was aware of the proposed development that early?
Could you point me to the specific area that you're
Sure. There's the sentence at the bottom of page 14 and it carries over to page 15 of your report.
It was based on the record showing that applications were being made by Coyote Springs of various sorts, where they were describing their project and beginning the process of getting approvals.
Thank you. And then the report next says that the state of Nevada Division of Water Resources was directly notified of every subdivision map listed above. Their recommendations were not received in a timely way, if at all, end quote. Can you explain what you mean by that?
Yes, the county is required to notify the State Division of Water Resources of tentative maps. They do that. There's record on in every one of these maps that their distribution sheet shows that the Division of Water Resources was included on the distribution. And with the exception of just a few cases early on, there is no record of any response from the Division of Water Resources.
And your report then says, quote, delayed responses and uncertainties are very damaging, costly, and sometimes deadly to a project, end quote. What do you mean by that, specifically as it applies to CSI?
Answer is really the beginning of that statement is more generalized I think often to a developer, but there's just a whole lot of carrying costs, costs for loans and financing of various sorts to provide the funds to do all these studies. And so every day interest is accruing. That gets to be another large order of magnitude when you're talking about a project of this size. So the additional costs that are being racked up are substantial, but sometimes the delays are deadly in that it causes the lack of action by one agency might cause them to miss a deadline for another agency and put them in a different cycle in a different year. They develop a plan for how they're going, a developer makes a plan of how they're going to approach their efforts based on the rules and regulations that are publicized. And they count on that process. And when if anyone does not fulfill the steps on any one of those steps in the process, then it could cause delays it definitely causes delays, but it could upset the plans for the rest of the projects.
And when you were reviewing the documents and materials you relied upon to prepare your report, you were aware that Coyote Springs and the state engineer entered into a settlement agreement relating to a fire lawsuit in August of 2018, correct?
I was aware, yes.
Okay. And in your report, you write, in addition to the statutory requirements, the legal action and resulting settlement agreement created a heightened obligation for the state engineer / divisional water resources to take prescribed action on these subdivision maps in a timely way, end quote. Can you explain what you mean by that?
Objection, foundation.
Sustained.
Are you familiar with the terms of that settlement agreement?
I am. It's a very simple agreement.
Okay, and what sort of duties or obligations did that impose on the state engineer?
To process the maps in good faith.
And in the ordinary course as well?
Yes.
Okay, and do those provisions have any impact on your review and your ultimate opinions in this report?
They do, because not only does the state then have the statutory requirements, but they've also, on top of that, agreed to process the maps in good faith and yes.
And based on your nearly 3 decades of government work, does it appear to you that the state engineer processed those maps in good faith?
It does not.
Based on nearly 3 decades of work experience, does it appear that the state engineer reviewed those maps in the ordinary course?
Objection, Vegas, that those maps.
The tentative maps that we were discussing earlier.
And I need to throw in there the final map because that's where the real action occurs. But repeat your question so I can sort of be answering it precisely.
Based on your years of experience, does it appear to you that the state engineer reviewed the 2018 tentative maps that we looked at, the 2019 final map, Mylar with technical report we looked at? Does it appear to you that those were reviewed in the ordinary course by the state engineer?
Objection, foundation.
Overruled.
It does not appear so to be in the ordinary course. It does not appear that the communication or the actions were straightforward or done in a timely way.
Can we take a look at Exhibit 3, please? And just blow up the top portion. Do you recall the date of the settlement agreement that you reviewed between CSI and the state engineer?
To look at my report, it was in May of 2018.
August.
Oh, I'm sorry. August of 2018. It was rescinding a May letter. I'm sorry, that's what I was referring to.
If I represent to you August 29th of 2018, does that sound right?
It does.
Okay, we can take a look at it if you need to. So this is an email from Jason King to various people within the state engineer's office, stated Friday, August 24th, 2018, a few days before that settlement agreement was entered into you. And I'll give you a moment to read this email. And just let us know when you're done.
I'm finished.
Okay. Does this email have any impact on your opinions?
It does. I'm surprised to see the state planning to deny somebody's application before even seeing it.
Is that concerning to you
It is.
as a former public official?
It is. It looks like there's a plan to obstruct.
And during the course of your government career, did you ever encounter a situation where a government official was internally planning on how future submissions from a developer would be rejected?
No,
And that's concerning to you?
that is concerning to me.
And having seen Exhibit 3, this doesn't contradict or change your opinion number 2?
It just underscores my opinion number 2.
Okay, thank you. We can pull that down, Hunter. And your opinion 1 and your opinion 2, are those made with a reasonable degree of professional certainty?
Absolutely.
Okay, let's finish up and talk about your opinion 3 then.
Okay.
What is your opinion 3?
Opinion 3 gets to be quite a bit more technical, more detailed, because it has to do with just one aspect of this whole project, and that is the large lot, the 8 large builder lot map that was submitted. The tentative map and as well as the final map that goes along with that.
So please explain your opinion number 3 for us.
So with these large lot maps, again, they are because any lot that's ever created has to be serviceable. It has to have a use. And these lots in this case were zoned probably on the underlying zoning was RU, which requires a minimum of 2 acres. But someone could, there's a use that lot can be put to. The use is typically one single family dwelling. And with a lot of that size, would meet the requirements for drilling a well in the state of Nevada, as well as the requirements for a septic tank. And so there is no intention at that point in time that water lines or sewer lines would be constructed to correspond with that map of the 8 builders lots. It's an initial map. There's intention for future phases, but if those future phases never occur, that map in and of itself is creating lots that are legal in the Clark County and the state of Nevada. With those lots, there have been numerous other large builders lots maps that were recorded within the Coyote Springs community. Each one of those had a commitment from the state, not from a water purveyor, but from the state for 2 acre-feet of water per lot. In this particular case, the land that's covered by this particular builder's lot map had already had 2 other maps recorded on that same acreage, that same land. And in each of those maps, water was committed already to that acreage. This map was declared in its title to be a re-subdivision of the earlier subdivision. So the water resources that were committed in those earlier subdivisions, which were recorded, were available to this builder's lot map as well.
And just so make sure that I understand or we understand what you're saying here. The large lot map tentative was submitted in 2018.
Yes,
Large lot final map was submitted in 2019.
yes,
We saw those earlier.
yes,
Each of those sought 16 acre feet
yes.
total. And your opinion is that or the basis for your opinion is that in 2007 and 2008, the state engineer previously approved maps, the same large lot map or the same area, providing and approving a total of 92 acre feet of water?
For that same acreage, yes.
Okay. And you would expect the state engineer, if they approved it previously, 92 acre feet for that same real estate, then they should approve this map seeking only 16 acre feet?
Yes, because they're re-subdividing the same exact land so that those original water commitments could just be redistributed to this lot configuration, same acreage, same land, just different configuration of lot lines.
Okay, let's take a look at Exhibit 12, please. Ms. Rinaldi showing you what's been previously admitted as Exhibit 12. I'm going to represent to you that this is a large lot map from October 2007. Do you recognize this document?
I do.
Okay. And we can see in the center column, bottom half, the Divisional Water Resources Certificate, there's a water commitment section. Do you see that?
I do.
And is this what you were talking about previously?
It is. You can see where they committed 2 acre feet per lot for a total of 56 acre feet.
And Robert Coach was,
I'm sorry, actually more, because that's just for lots 1 through 28. And then there are 2 resource lots that they also committed the 2 acre feet. So it's 60 in this case.
do you know who Robert Coach was in October of 2007?
Bob Coachy was an engineer that worked in the state engineer's office.
So Exhibit 12 is one of the documents you relied upon in forming opinion brief?
Yes.
Okay, and Hunter, could we take a look at Exhibit 18 next? I believe on this one, it's going to be a right column. The column on the right side. Have you seen this document before, Ms. Rinaldi?
I have.
Okay. And is this the October of 2008 map that you referenced in your report?
It is.
Okay. And this also contains a certification from the state engineer approving water for that same large lot map?
It does.
Okay. And you had it a moment ago, Hunter, that, yeah, there you go. Thank you, sir. And we see the water commitment here.
Yes.
Okay. And the Exhibit 18, what we're looking at now, and Exhibit 12, the map from 2007, both of those, the state engineer approved a higher allotment of water than what CSI was seeking in 2018 and 2019. Would you agree?
I agree.
Okay. And let's look next at what's been marked as Exhibit 297. And if you can blow that up so it's easier to see, that would be helpful. Ms. Rinaldi, do you recognize Exhibit 297?
I do. I asked Coyote Springs engineers to create this exhibit for me because I wanted to see how those previously recorded maps overlaid the area that was the subject of the 2018 large lot map.
You wanted to make sure you were comparing apples to apples?
Yes, and apples in their locations to apples in the same location, yes.
Okay. And what does this Exhibit 297 tell us?
Well, the outline in like a heavy line of orange, that is the boundary of the 2018 8-lot builders map.
Okay.
The area that's in, let me get the right colors here. We're going to not pay attention to the green striped area or the magenta striped area on the left because it didn't cover the same land area.
Okay.
The state engineer made water commitments to that location, but we didn't count those. We just looked at where the maps overlapped each other, and the dark gray area is where. So let me back up and say the blue striped area is the map that was recorded in November of 2008,
okay.
And it committed 32 acre feet. The red striped area is the first map that we'd looked at. It was recorded in 2007 that commits 60 acre feet. You can see it covers a much larger area. So I wanted to find out really where this 2018 builders lot map specifically overlapped. And you can see that it's the land area in the 2018 map was entirely recorded in the past, had builder's lots recorded on it entirely in the past, with the exception of the white spot in the top right. But the map recorded in 2007 gave 60 acre feet, and in 2008 gave 32 acre feet. And in some cases, those two maps even overlapped. And so there is more than 16 acre feet of water that is already committed to the land area outlined in orange. And that the land area that wasn't covered by a previously recorded map is part of another lot to the left of it that already has more than 2 acre feet committed to it. So,
And if the state engineer, let's say that 2007 final map was recorded, if the state engineer down the road changes his mind or her mind,
No,
there are vehicles for them to withdraw or file an objection to that previous final map, right?
I know of none.
They couldn't step up and do something about it?
And I know of none.
Okay. And
Once the map's recorded, it's in perpetuity. That lot exists.
you could record something against that map to put some people on notice, correct?
You could.
So your opinion is based on those prior approvals in 2007 and 2008, state engineer approved a greater amount of water, that these 2018 and 2019 large lot maps should have been approved.
Yes, that this map required no greater commitment of water than had already been made for this exact acreage.
Okay, can we take a minute, or maybe, I don't know if I'm running long, maybe take a break, just, I may be done, just want to consult with my
We'll
team.
take our recess now until 3:30.
Thank you.
From the session.
Go back on the record. You may resume. The witness having taken the stand.
Your Honor, we've concluded our direct examination. We'll pass the witness.
Cross.
Thank you, Your Honor. Mr. Rinaldi, my name is Matthew Neal. I'm one of the attorneys for the state engineer. How are you?
Well, Matthew, thank you.
I'm gonna ask you some questions on what they call cross-examination. I mean, no offense. Please don't take any if one of my questions doesn't make sense, just ask me to repeat it. And I'll try my level best to do so, okay?
All right.
Where do you reside?
I reside in Ashland, Oregon,
How long have you lived there?
20 years.
You're a land use consultant, right?
And
Your rather illustrious career has been in planning and local government, right?
yes, it has.
By the way, do you know Nancy Amundsen?
I do.
How do you know her?
She was hired by the county when I think I was either assistant planning director or assistant county manager. And she worked in major projects at Clark County.
She worked with you while you were there?
We didn't actually work together, but she worked there at the same time I worked there. And then I had another experience with her. I think we met on one or maybe two occasions when I was representing private landholders.
You understand that you both issued expert reports in this case?
Yes,
In fact, you did a rebuttal of hers, right?
I did.
You think that she's qualified to opine as an expert in the same manner you have?
I don't know about the same manner as I have, but I think she's qualified to opine as an expert.
Okay, but you're not a hydrologist, right?
Correct.
Not a hydrogeologist,
I am not.
not a groundwater modeler,
I am not.
not a water rights engineer,
Correct. I am not.
never served as the Nevada state engineer,
No, I haven't.
never worked at the Nevada Division of Water Resources.
I have not.
You're not offering any opinions in this case interpreting Nevada water law, right?
Correct.
You're not offering any opinions concerning priority under Nevada's prior appropriation doctrine?
Correct. I'm not.
And you're not offering any opinions concerning whether groundwater is available for residential development at Coyote Springs, right?
Correct.
In fact, you wouldn't be qualified to opine as to the availability of groundwater for residential development at Coyote Springs, would you?
I am not.
But the Nevada state engineer is, right?
Yes.
This is the first time that you've been qualified by a court as an expert, right?
Yes. And I wasn't actually qualified as an expert yesterday.
Oh, you recall my objection yesterday
I
and
did.
Judge Denton recognized you as an expert. So that's the first time
Well,
you've been
that counts.
recognized as an expert.
Okay.
Congratulations. You're being paid for the work that you're doing in this case, right?
Yes.
Do you know how much you've been paid to date?
No, but that question was asked during my deposition, so I took a look and it's between $35,000 and $40,000. All told over 4 years.
That's hourly,
Yes.
and you know approximately how many hours you've worked on this case?
Boy, I didn't total the hours. No,
You haven't authored any publications within the past 10 years, right?
correct.
And because this is the first time you've been qualified as an expert before a court, you haven't testified as an expert witness in the past 4 years, right?
Correct.
You were first retained in this case in 2022, is that right?
That's right.
By Mr. Coulthard?
Yes,
And you were retained to provide an expert report, is that correct?
it is.
You prepared that expert report in the 2022-2020 timeframe, is that right?
2022, what time?
2023, 2022, 2023
I
timeframe?
did initially
And you submitted that report to Mr. Coulthard and Mr. Robeson, is that right?
as a draft, yeah. To Mr. Coulthard and who?
Mr. Robeson, Ken
Yes.
Robeson?
Mhm. Yes,
In your deposition, you said you spent at least 20 hours on that report, was that correct?
at least 20 hours.
But you were specifically asked not to finalize it because of the direction the case was going at the time. Do you remember that?
I do.
And then you were re-engaged several times and several times involved in meetings, but then asked not to produce any further work product, right?
Correct.
And then your most recent engagement was by Mr. Hutchison's firm, late 2025, early 2026, is that right?
Yes, late 2025, if I recall correctly.
And as a result, your deposition was taken in this case, you remember that?
I do.
It was March 2026, does that sound familiar?
That's
You were designated as both an initial expert and a rebuttal expert, is that true?
I'm not sure what that means,
You
to be
you did,
designated.
excuse me.
I'm not sure what to be designated means.
Council has hired you to do both your initial report, which had the foundational opinions that you gave to Mr. Hornquist during your direct examination. And then you also did an additional report that's called a rebuttal report to Ms. Amundson, is that right?
That's right.
And one of your opinions is that the county is responsible to coordinate with outside agencies such as the Division of Water Resources to ensure there is a source and delivery system for potable water for every new lot and development within its purview. Is that right?
Be quoting from something that I stated or read?
I am. That's a quote from your rebuttal report. Do you have that in front of you?
I don't have.
You want to take a look to confirm I'm not telling you lies?
Yes,
Your Honor, I'd object that it's out beyond the scope of direct. I can get into this down the line when Mr. Rinaldi responds to Ms. Amundsen's testimony, but
Let's see where it goes.
Yeah, let's see what it goes. I can send it to me. First tab is your initial report, second tab is your rebuttal report. I'm on page 4 of your rebuttal report, tab R. Just let me know when you're there.
I'm on page 4.
Okay.
And where, can you point me where you were reading from, please?
Yeah, bear with me. About halfway down, the paragraph starts with according to Clark County Code.
Yes,
So my question was, if you want to take a minute to read that and then raise your head, I'll know when you're done. My question was, it's the county who is responsible to coordinate with outside agencies such as the Division of Water Resources and Las Vegas Valley Water District to quote, ensure that there is a source and delivery system for potable water for every new lot and development within its purview. Is that right?
it's the county's role to coordinate. It's not their role to ensure.
Nevertheless, you agree that master plan communities require water,
I do.
and without an adequate supply of water, source and delivery system, a master plan community can't ultimately be built, right?
Correct.
And identifying and finalizing an adequate supply of water was a unique concern for Coyote Springs. Is that right?
Yes, unique to Clark County. I mean, it happens other places in the state on a more frequent basis, but yes, it was unique for Clark County.
It was unique for Clark County because Coyote Springs is outside the Las Vegas Valley Water District service area. Is that right?
Yes, and outside of the Moapa Valley water, any service, or any water district service area at the time.
So it's fair to say that the county, every agency in the state, and most every person living in Clark County is aware that water availability is limited and is a potential constraint on development. Agreed?
I think I said that, yes.
Water availability is one of the many risks faced by developers. You agree with that?
I do.
And developers understand that risk before they invest, don't they?
Yes,
And large developments like a master plan community routinely invest millions of dollars even before every governmental approval is secured. Isn't that right?
I do.
And that's part of the development process.
Yes,
And the developers decide whether to continue making those investments, don't they?
they do.
The government doesn't force them to invest.
Correct.
On direct, you mentioned Summerlin. Do you recall that?
Yes.
And one of the things I wanted to ask you about was that, did you say Summerlin started as a development within the city of Las Vegas and then expanded into Clark County?
Yes,
That's, you consider Summerlin a single master plan community, right?
well, from my own personal experience, there's a clear demarcation line. I was much more involved with Summerlin South than the rest of Summerlin, but I know that the community thinks of Summerlin as one.
Even though it crosses the political boundary line between the city and the county, right?
Yes,
And in fact, you, as you just testified, you worked on the Summerlin South phase of that development, right?
I did.
I think you said you led the negotiation of the development agreement for that phase. Is that right?
That's correct.
And that one of the reasons why Summerlin expanded into Clark County was to have access to the county's water allocations?
That's my opinion at the time. There were other reasons, but that was one of them.
But the source of water was the Los, they were able to do that because they were within the Las Vegas Valley Water District service area, correct?
Yes, and because at that time, each jurisdiction was allocated a certain amount of water so they could continue up until they reached that cap to approve development.
You agree that in the early 1990s, it became apparent that the quantity of available water resources could be a potentially limiting factor for development in Clark County?
Yes,
So development in the remote areas, such as where Coyote Springs is located, was allowed if and only if the developer could provide adequate public facilities, including water, right?
correct.
In other words, the government is not going out and providing water for the development. It's the developer who's bringing the water to their development.
Objection based.
Yeah, it gets
Sanders'
complicated. When you're within a service area of a water district, now water district is government. So once you're within that service area, that government jurisdiction is bringing water to you. But in the case where there isn't a water district, the landowner has to bring the water to the table.
Such as in the case of Coyote Springs.
Yes,
Lindsay, can I have exhibit 3307? (3307) Recognize this as the Clark County Development Agreement you glossed over with council on direct.
I do.
If we look at the date in the top right-hand corner, I think we'll see, Lindsay, if you can enlarge the received conformed copy up in the top right corner in black. That appear to you September 16, 2004.
Yes,
And Lindsay, if we can go to page 51. It's a signature page. We'll see the signature of Robert Dirk, General Manager for CSI. Do you see that?
I do.
If we go back, Lindsay, to pages 9 and 10, if we can split screen pages 9 and 10 on the screen. This was that section that council drew your attention to, but I feel like you didn't spend enough time on it. So let's just dig in real quick. First of all, at the top, we're looking at section 2, recital of premises, purpose, and intent. Is that right?
Yes,
And then it's section 2.01, it says recitals. And then it says this agreement is predicated upon the following facts and findings. If we look down, Lindsay, can you enlarge sections F and G on the screen at the same time? Yeah, so F is the last one, and then we'll need G at the same time. It's okay, standing by.
Yeah. Great. Ms. Rinaldi, can you see that on your screen?
I can,
Is it big enough for you to read?
yes.
Can you read section F and stop after owner recognizes sentence? So when it gets to it is not the intent, you can stop there.
Sure. Acknowledgement of uncertainties. The parties acknowledge that circumstances beyond the control of either party could defeat their mutual intent that the planned community be developed in the manner contemplated by this agreement. Among such circumstances are the unavailability of water or other limited natural resources, federal regulation of air and water quality, and similar conditions. Owner recognizes that water shortages could affect the county's ability to perform its obligations hereunder.
And section G, we'll look at that now. I'll read that one since you did the heavy lifting on F. Provision of water and sewer service. Owner clearly understands and agrees that among other requirements, water commitment and sanitary sewer system development approval must be obtained from the proper governmental entities, namely the Las Vegas Valley Water District, Clark County Water Reclamation District, the Mawapo Valley Water District, or others. This agreement or county does not guarantee the provision of water and sewer services. Lindsay, can we also have 3313 now? You recognize this as the development agreement for the Lincoln County side of Coyote Springs?
Well, I haven't looked at that in 4 years, but I see that its title is Development Agreement between Lincoln County and Coyote Springs. Yes.
Right, and if we go to page 39, Lindsay. We'll see that there's an effective date. Yeah, under the first set of signatures, the effective date hereof is February 1st, 2005. Do you see that?
Yes.
And again, this is signed by Robert Dirk on behalf of Coyote Springs Investment LLC, right?
Yes.
Okay. So Lindsay, if we turn back to pages 5, I don't suppose you can get 3 up, right? Just 2 at a time. Let's do 5 and 6 first, and then we'll adjust as we go. Just take a moment, since you said it's been a while, and look at section 2 there towards the bottom on your first screen. See if that looks generally similar, if not identical, to the Clark County one we just looked at.
I didn't pay attention to that particular.
No, excuse me. I think that the highlighting is just confusing, and that's my fault because I asked a really poorly structured question. You see at the bottom of the screen on 005 where it says section 2,
Yes.
recital of premises, purpose and intent.
Yes,
That's the same language we just looked at in the Clark County agreement, correct?
it is.
And it's again, section 2.01 recitals. This agreement is predicated upon the following facts and findings.
I see that.
The same language we just looked at in the Clark County agreement?
Yes.
Okay. So Lindsay, now if we can have 6 and 7, we can enlarge F and G again. Section F is again the acknowledgement of uncertainties. Very similar, if not identical, to the Clark County agreement we just looked at. Do you agree with that?
Yes, I do.
And section G, provision of water and sewer service. Does that language appear to be similar, if not identical, to the Clark County agreement?
It's similar, but with the exception that there is not mention of the various water and sewer service providers.
Right, okay. The language I'm concerned with in G there, is that where you were drawing the distinction?
Yes.
It says this agreement or county does not guarantee the provision of water and sewer services. That's identical to the Clark County agreement, right?
I think so, yes.
So, Lindsay, you can take those down. When CSI entered these development agreements, it knew then that its development plans might be frustrated, right?
Objection calls for speculation.
She can state her understanding.
For a million reasons, yes,
Including water unavailability, right?
yes,
I mean, we just looked at the language. It says owner clearly understands and agrees there's no guarantee of water. We emphasize that, right?
yes,
We said the circumstances beyond their control could defeat their intent to develop the master plan community, right?
correct,
And among such circumstances, the unavailability of water, right?
correct.
On direct, you mentioned you were a consultant for Glendale Holding Company. Did I get that right?
Yes,
That was the Riverview development, wasn't it?
yes, it was.
That was 7 separate property owners who wanted to build a master plan community in Moapa.
Correct.
Your clients were major home builders, right?
Several of them were,
One of them was a
One-
national home builder,
correct.
and they hired you to obtain the entitlements,
They did,
and you did so.
pretty much. Didn't finish them because the market fell apart.
In your words, at least up until the time the real estate market fell apart, as was my next question. Anticipated it. Thank you. That was the 2007, 2008 time period.
Yes, approximately.
And because of the shift in the economy, your clients abandoned the project, right?
Yes, they did. There was no single family homes going to be built, so there was no reason to pursue further entitlements at that point in time.
In your deposition, you agreed it wasn't economically feasible at the time to pursue a master plan community, right?
Correct.
Because the demand for single family homes disappeared.
It did, and that is really contingent on their time frame. Much smaller acreage can't really be compared to Coyote Springs, and they had intended to turn their properties into homes in very short order, and so the near-term market for single-family homes just did not exist at that time.
What was the total acreage of the project?
Wow, I'm not sure I can remember that.
More or less than 1,000 acres?
1,400 is sticking in my mind, but that's just a vague recollection.
Yeah, and that was in Moapa. That's the same general location as Coyote Springs though, right?
More or less, yes,
50 or 60 miles outside of Las Vegas.
yes.
Moapa Valley is a fairly established community though, isn't it?
Moapa and Moapa Valley are two different places.
Moapa Valley is larger. It includes Moapa, correct?
I don't know that it includes Moapa. Moapa Valley is the other side of the highway and down in the valley. Moapa is on the west side of the highway and totally independent.
My understanding, you can correct me if this is not your understanding, but that Moapa Valley includes Overton, Logandale, and Moapa.
I believe that what I've always referred to as Moapa Valley is Overton and Logandale, not Moapa.
Not to include Moapa, okay, but the Moapa Valley Water District is the municipal water purveyor in that service area, correct?
Yes,
Your clients had surface water rights on the Muddy River, is that right?
they did.
And certificated groundwater permits already put to beneficial use through irrigation, yes?
Correct.
They had some level of certainty then or assurance that water would be there after they developed their project, true?
Some level of assurance for some of their water rights, correct? Not all of their water rights.
Well, they were within a municipal water purveyor's service area, yes?
I'm not sure that they were that all the properties were within their service area. Moapa Valley Water District provided service to parts of Moapa, but some of the properties that I was working with were more remote. And I'm not sure that it was technically within their service area. I can't recall that whether it was or not.
No problem. They had surface water rights on the Muddy River, which are the most senior kind of water rights in Nevada, you agree?
Yes,
And certificated water rights, meaning they've already been used and proven.
for agricultural purposes, yes.
Right. When I asked you the question that they had some level of certainty or assurance that water would be there after they developed, do you quarrel with that?
I do. We did not feel as though there was a high degree of assurance.
In the binder in front of you, there's a tab that says D. Do you see that?
I do.
That's your deposition transcript. Let's take a look at that question and your answer on page 40. I'm at line 22 on page 40. The question reads, did those partners secure those water rights certificated in the Muddy River surface water rights in advance of you seeking or beginning the entitlement process? And your answer?
They did.
The next question, is that typical that a developer is going to seek and obtain some level of certainty with respect to the water rights before they begin the entitlement process? And your answer?
Yes, absolutely.
You can finish it.
And then continue to acquire additional water rights. They secured water rights, but with different points of diversion and for different uses. There was a lot that needed to happen in order to convert those to municipal use and deliver them to the Moapa Valley Water District.
Understood.
None of those steps were assured.
On your opinion one, you've been using the general phrase Coyote Springs, and I want to draw your attention to something. Maybe you can help me clarify it. You understand that there's 3 plaintiff property owners in this case, right?
Yes,
Your opinion one is that Coyote Springs did everything they needed to do to obtain their entitlements, perfect their entitlements, pursue their development, right?
yes,
Okay, you understand that Coyote Springs Investment LLC, Coyote Springs Nursery LLC, and Coyote Springs Nevada LLC are 3 separate entities, right?
I do.
So when you're saying Coyote Springs did this or that, which of the entities are you referring to?
Collectively,
You make no distinction.
I make no distinction.
You don't actually know which entities did what, you just group them all together in your mind.
That's true.
I wasn't sure whether you were offering this opinion or not, but then counsel kind of danced around it, kind of didn't. In your deposition, you said that your opinion was that CSI spent tens, if not hundreds of millions of dollars of work toward developing its entitlements. Do you remember that?
I do.
And then we asked you from a dollar perspective, what's the foundation of that opinion? And you couldn't give one. Do you remember that?
I did give a foundation, but I said that, for instance, I did not see a listing of expenses ever. So I don't know an exact dollar amount, but I recognize that the order of magnitude of the investment based on seeing similar projects and similar improvements for other projects was not only very large, but had to be in the tens to hundreds of millions of dollars because I was aware of costs of other projects of a smaller size.
Right. We asked you about that in your deposition, and you said it's what you had in your mind envisioned the costs and expenses associated with what you perceived to have been constructed, right?
With what I saw be constructed, yes.
Right. That's not information that was provided to you, though.
No,
But the fact that they spent so much money is, in your mind, supportive of your opinions in this case.
it's part of the support. I mean, it's not just money, it's time, effort, and money.
And I think counsel asked you what you did to prepare your opinions or come to your opinions, and you said you reviewed county records
I did.
and you took a site visit and took pictures. Excuse me.
Yes, I did.
But the county records didn't tell you what costs and expenses were incurred, did they?
In a way they did, because I saw that they were building pump stations and flood control detention basins and other similar kinds of facilities. County records showed that they made application for them, and then I saw them with my own eyes when I was out there on tour.
Page 63 in your deposition, please. I'm at line 14. You with me?
I am.
The question was, okay, and the county records don't tell you what the costs and expenses are, and your answer?
They do not.
But you know that along the continuum, the property was sold to Party Homes of Nevada, correct?
I do know that, yes.
And you don't recall the circumstances or terms of the sale, do you?
I'm not aware of them.
You hadn't reviewed the purchase and sale agreement?
No,
You don't know how much acreage Party purchased?
no,
You don't know what they paid?
I do not.
Do you know what CSI paid Party when they got it back?
I do not.
Do you know whether any of the improvements that you perceived on your site visit and through the county records were constructed by Party Homes?
I do not know by whom they were constructed.
Okay, so when you say CSI spent all this money or followed all these steps, you don't know whether it was actually CSI or Party Homes, right?
I do not.
Or some other entity for that matter.
That's correct, although I can't imagine any unrelated entity making an investment on someone else's property.
You don't know how much CSI actually put in to develop the property, do you?
I do not.
You say they spent millions, but you don't know how much money they spent.
When I say they in that kind of context, I'm speaking of they and their partners in the development of that community.
But you do know, I think you testified this on direct, that CSI intended to build, did you say 160,000 homes?
That might have been the total. I think there was only something less than 50,000 homes in Clark County.
It was 49,000 in Clark County. Mr. Carter will correct me if I'm wrong. It's around 49,000 in Clark County, right?
Yes,
And then they were going to build around 110,000 homes in Lincoln County, right?
but I recall, yes.
And so you understood that the master plan community was going to be all 42,000 acres out there, right?
Eventually, yes.
Across the political boundary line between Clark and Lincoln County.
Yes, but everything that I reviewed, everything that was submitted to Clark County had to do with what could have been a standalone community in Clark County. It had to be considered that way because Clark County has no jurisdiction outside of its county boundary, and because it had to stand alone. The county could only approve what's within its jurisdiction, and then what they did approve had to be able to stand alone because they have no control over anything outside. So what they approved was could have been a standalone community, had to be considered that way.
Did you say that development agreements are akin to enforceable contracts?
That's my understanding, yes.
Would the development agreement take whatever you just said about jurisdiction and standalone, but that take it outside the development agreement would control at that point, right? So whatever the development agreement says about what's standalone and who has what jurisdiction, that's where we're going to look to find those answers.
I'm not sure I follow you.
So if they had coordinated entitlements, meaning if there are references within the Clark County development agreement to what Lincoln County was going to do and vice versa, that would give us the best indication as to what the landowner intended to do with this property, right?
I don't think I can conclude that because it's pretty broad and because Clark County could only make commitments for Clark County and certainly not for Lincoln County.
I'm asking, wouldn't the development agreement control the answer that you just gave as opposed to whatever the ordinary course is?
Well, I sure don't understand the application of your question. I don't.
No problem. It's probably too confusing, but you agree that the master plan community across Clark and Lincoln County lines was going to be a single economic unit, right?
Objection Vegas, single economic unit.
She understands it.
I do not know how Coyote Springs envisioned, if they considered it a single economic unit. I know that the consideration for Coyote Springs within Clark County was considered a single economic unit within the land that was only in Clark County and had to stand alone as a self-sufficient or, as a complete community by itself, just the part in Clark County.
I'm sorry, did you say you don't know what CSI intended?
I do not know what they intended in terms of what they considered a single economic unit.
Did they intend to build a single master plan community?
In phases, and yes,
That's typical of master plan communities. You build in phases.
that's correct.
I think in your report or in your deposition, I saw some, you don't just come in and have a big old community on day one, right?
Correct.
You have to take it in chunks.
That's right.
I think you went through that with Mr. Hernquist.
Mhm.
Was Nellis Air Force Base involved in the entitlement process for Coyote Springs?
They were.
How so?
My recollection is that they filed some objections because of their flight patterns and potential impacts to restrict their flight patterns and their exercises that occur out of Nellis Air Force Base.
Did you form the understanding that Nellis was objecting because they're flying live munitions over the Coyote Springs property?
That's my
Objection, lack of foundation.
She just asked for her understanding, so. I'll allow it.
That was in the county record. Yes.
Have you ever worked with Harvey Whittemore?
Have I worked with Harvey? I knew of Harvey. I don't believe I ever actually worked with him.
I think when we were looking at those development agreements, we were in the 2004, 2000 timeframe. Does that ring a bell?
Sorry, when we were looking
Looking at those development agreements for Clark County and Lincoln County? I'm just trying to reorient in time. We were in the 2004, 2005 timeframe. Do you remember that?
I do.
Okay, do you know what the manner of use of CSI's water rights was as of the date the development agreements were executed?
I do not.
Okay, turning to your opinion number 2. In essence, the state engineer should have approved the maps to allow vertical residential construction to commence and home sales to begin, right?
I hesitate to answer it just that way. The state engineer has nothing to do with vertical construction, but the state engineer should have approved the maps to allow those lots to be created.
What would have been the effect of that?
Once the lots were created, then residential development could have occurred.
Turn to page 13 of your initial expert report, please.
Yes.
Opinion 2 is bolded. And you see the second full sentence.
Yes.
Can you read that to yourself and let me know when you're done?
Yes.
And my question was, your opinion 2 is that the state engineer should have approved the maps to allow vertical residential construction to commence and home sales to begin.
What I said was the state engineer should have allowed the maps to record, which then would have allowed, but the state engineer doesn't cause vertical construction.
I think my point is that what you're saying the state engineer should have done would have resulted in homes being built and home sales, people moving in.
That's true.
You said in your deposition that the development of a master plan community is a very large and complicated process. Do you remember that?
I do.
I think you said the same thing on direct. Do you recall that?
I do.
And that it's risky, right?
It's true.
One of the risks is that the developer may not have water to support their master plan community, right?
That's one of the risks.
The economy is a risk as well.
It is.
We talked a little bit about that with Riverview.
Yes.
But as to water, before you formulated your opinions for this case, you didn't review the water permits that CSI owns, right?
Correct.
And because you didn't look at those permits, you don't know whether the permits are conditional or unconditional.
I do not know that for fact. Most permits have some conditions attached to them, but I do not know that for fact.
You didn't review, for example, ruling 4542 by the state engineer, the Nevada power ruling?
Right, I did not review that in detail.
You didn't review ruling 5712, the Cane Springs ruling, did you?
I did not.
Ruling 5918, the Tuffy Ranch water ruling?
I did not.
You didn't review 6254, 6255, the pump test rulings?
I glanced through those.
Did you review order 1303 that established the administrative hearing process?
I did read that.
You read the whole order.
I believe I did.
Order 1309?
Yes.
Nevertheless, you don't know what criteria the state engineer employs to verify water availability at the final map stage, right?
The question is, do I know the criteria that the state engineer uses to verify water?
Correct.
No, I'm not familiar with all the criteria that they use.
In your deposition, we asked you this and you said you do know that the water has to be available in perpetuity though, right?
True.
And when CSI submitted its final map to the state engineer in June 2019, you don't know whether water was available in sufficient quantity in perpetuity, do you?
I do not know personally, but there was a report submitted that said that it was.
Somebody told you that water was available. You're not offering that as an expert opinion, right?
Correct.
Because you're not a hydrologist.
Correct.
And you're not qualified to render an opinion with all due respect on the availability of water.
Correct.
But the state engineer is qualified to do that, right?
Correct.
And candidly, you don't know why the state engineer didn't approve that map, right?
Which map are you speaking of?
The June 2019 submittal?
I know what he stated in his letter, the reason was, but no, I don't. That's all I know, what was in the record.
Yeah, in your deposition, we asked you and you said you didn't know what the state engineer considered or didn't consider, right?
Correct.
You do know, however, that there was, from your review of Order 1303, that there was an ongoing administrative process to determine exactly that, how much water was available in the region, right?
Yes,
Do you understand that that process occurred between January 2019, at least, the issuance of Order 1303, all the way through until June 2020, when Order 1309 was issued?
that makes sense to me. I don't have any particular knowledge of it.
Do you know that that process is still ongoing?
No, I'm not aware of that.
I want to take a look at that timeline council admitted into evidence as 553. Lindsay, do you have that? Let's take a look at 553001. And Mr. Rinaldi, I think this is in front of you. I'll try to refer to it by the Rinaldi Bates stamp to direct your attention to what page I'm at, because unless yours says 553, does it?
No.
Okay. It'll have it on the screen. You also have a hard copy in front of you.
Or is that creation? Cameras or something.
So a moment ago, we were talking about the administrative process that occurred at a minimum between January 2019 and the issuance of Order 1309, June 2020. Do you recall that?
Yes.
There are, however, indications on your timeline that the administrative proceedings, the whole process that culminated in Order 1309 started much, much earlier. Do you understand that?
No, maybe you can point me to it.
I'll see if I can try. Let's look at page 1 of that timeline. And there's an entry for 2002 parentheses in March. You see that?
I do.
And it says Order 1169 is issued. Insufficient info to grant additional water rights. CSI and others paid for infrastructure for 2-year pump tests of 50% of volume of currently permitted rights, including CSIs listed above. is the full extent of information you know about that pump test incorporated in that little box?
No,
You know more about the Order 1169 pump test?
well, I know that the actual pump test occurred 8 years later, started 8 years later. And continued for 2 years. And so I know more than what's in that box.
Okay, and then there came a point in time when the results were published, right?
Yes,
And we'll get to that, but at least based on your summary, you understand that there was a pump test in 2002, correct?
not that there was a pump test, but that there was an order.
Ordered, pump test ordered in 2002, excuse me, thank you for the
Yes.
clarification. Lindsay, can we turn to page 6 of that document? Oh, no, I'm sorry, not page 6. It's Rinaldi 006. So it's, May 2002. It's the next entry on page 1. Apologies, Lindsay. Yeah, May 2002, Coyote Springs Public Facility Needs Assessment approved. You see that?
I do.
Did you review the PFNA?
I did.
Do you recall how much water CSI represented to the county they needed to build their master plan community?
I don't recall the number.
Do you recall what the PFNA said about the early warning contingency program?
I don't recall that particular term.
Lindsay, let's pull up exhibit 3281. You recognize that as the PFNA?
I do.
And we'll go to page 61. Lindsay, please. You see the tables and the writing on the right hand? Is it on the right hand side of your screen there, page 61? Tables and such?
It looks like it's page 60, but, oh, I see, 61 on the Bates
Okay.
numbers, yes.
Yep. Overall water usage, 34,000 acre feet per year.
Yes, I see that.
And then overall withdrawal of groundwater resources from the planning, or for the planning area, excuse me, in the bottom table. Overall groundwater withdrawal, 23,000 acre feet per year.
I see that.
So this is CSI telling the county how much water they need to build out their community, right?
Correct.
And then Lindsay, if we go to page 52. This is the early warning contingency program I was talking about.
Oh, I see. Mhm.
Have you read this before?
I have. I skipped the title of the section and just was reading the text.
You need a minute to review it before I ask you questions about it?
That would be good.
Okay, take your time and just let me know when you're done.
I've read it.
Okay, if we look at the first page, this is dated April 2002, right?
It is.
So shortly after Order 1169 is issued, CSI puts together its PFNA, submits it to the county, application for a major project in Clark County. They tell the county how much water they need, right?
They do.
And then there's gonna be a regional monitoring plan that will provide additional safeguards by monitoring some reasonable quantity of annual production from the carbonate aquifer. Do you know what carbonate aquifer is a reference to?
I generally know what a carbonate aquifer is, but beyond that, I don't know.
Do you know that the carbonate aquifer relevant to this case is where CSI has its water rights that it alleges were taken by the state engineer?
I can't say that I could know that detail.
Okay. From the carbonate aquifer in excess of the committed usage as a part of the early warning contingency program. Since the possibility exists that pumping of groundwater resources in the Coyote Spring Valley, you understand the Coyote Spring properties in the Coyote Spring Valley,
I do.
could lead to a significant drawdown in the vicinity of the Muddy River Springs. It is necessary to develop a program that can test certain scenarios and provide recovery mechanisms should the results indicate any significant impact. Does that paragraph have any meaning to you?
It does.
What does it tell you?
It tells me that there's a framework in place to basically, in layman's terms, prove up the water rights, that they can be used without detrimental impact to the Muddy River.
It's a concern that the use of the groundwater in Coyote Spring Valley will impact the Muddy River, correct?
It's that, and it's a framework for exploring that with contingency plans along the way.
Do you need a contingency plan if there's not a problem you're addressing in the first place? Objection calls for speculation.
If she knows.
That seems like a very generic question. I don't know how necessarily my answer would relate here.
Such a program will provide a means of obtaining useful monitoring data regarding aquifer stress and resulting impacts, if any, to provide a period of recovery in which carbonate production could be reduced at one or more locations prior to being committed to a permanent use should significant impacts to surface flows at the Muddy River Springs be detected by federal bureaus as outlined in the regional monitoring program. Any additional significance to that paragraph for you?
One moment, I'm reading it again. No additional significance. Again, provides a framework for examining the water.
This is CSI's document, right?
And the county, no, I'm sorry, this is the CSI's document.
CSI submits this to the county
Correct,
in advance of the development agreement.
correct,
This is one of the things the county is relying on in signing the development agreement.
correct.
One of the reasons they put in there about uncertainties and water availability, this is attempting to address that, agreed?
It might be that language is in every development agreement, but this is to address the provision of water, which is required in the PFNA.
We agreed at the beginning of your cross-examination that the Coyote Springs development was somewhat unique within Clark County. Isn't that true?
That is true.
There was a unique concern about water availability, correct?
Not on the part of the county. It didn't appear to be unique. They appeared to use their standard language in their development agreement.
This is CSI telling the county, we recognize our pumping could be restricted if we impact the Muddy River, is it not?
That's how I would read it, yes.
Will you turn to Rinaldi 7 on your timeline? It's page 2 of 553. Lindsay, we can go back to 553002. So I'm on page 2 of your timeline. You with me?
And
3/4 of the way down, there's an entry in July 2006. Lindsay, we can get there. July 2006, tentative map, 54 residential lots. Do you see that?
I do,
Is that one of the things that you came across in your review of the county records?
it is.
Okay, and you have a note there that the state that's state engineer, right?
Yes,
Recommended disapproval in August after county had already approved. You see that?
yes.
Lindsay, if we can pull up exhibit 3370. We can split screen that. Two-page document. This is the August disapproval by the state engineer you're referring to, is it not?
I'm reviewing it. It is.
Okay, and it says, well, excuse me, on page 2, you see the CC to CSI, Coyote Springs Investment also, you see that?
I do.
We can scroll back out. Okay. If you follow along with me under general, it says the tentative map indicates that the source of water is to be from Las Vegas Valley Water District. To date, no letter has been received by this office indicating that there is sufficient water for the subject subdivision. Did I read that right?
I believe so, if you're asking me.
And then the action is recommend disapproval to water quantity as required by statutes for the Coyote Springs Parcel 19 subdivision based on water service by Las Vegas Valley Water District, comma, until such time that written notification addressed to this office is received, listing the water right permits from the water purveyor with an indication that it has both sufficient uncommitted water rights and developed water source capacity to serve the proposed subdivision. Right?
Yes,
You know what a will serve letter is?
I do.
What is it?
It's a letter stating that water purveyor has sufficient quantity of water and the means to distribute that water to serve the lots in question.
You understand this letter to be saying to CSI that they need to submit a will serve letter the next time they submit a subdivision map?
I wouldn't say exactly that. It's an indication that they would need a will serve letter before they could record a map. Tentative maps don't require a will serve letter. And at this point in time, the GID that was to serve Coyote Springs didn't even exist yet. So it was all in process.
Right. I don't see a reference to the GID. I see reference to Las Vegas Valley Water District.
And I'm not sure why. The Las Vegas Valley Water District ended up being the manager of the GID, but the GID was not created until later. It was probably under discussion at this time, but didn't exist.
Yeah. You know that CSI's water purveyor ultimately became the GID, right?
Yes,
And when we say GID, we're referring to the Coyote Springs Water Resources General Improvement District. I think there's a Clark County in there as well.
I think you're right.
We have the same understanding.
Yes,
And you think you indicated it's managed by the Las Vegas Valley Water District?
correct.
And you know that neither the GID nor LVVWD ever submitted a will serve letter for Coyote Springs to the state engineer, right?
I know that, correct? At least not up until the point of 2022.
You turn to Rinaldi 9. This is going to be 553004, Lindsay. Mr. Rinaldi, I'm on your timeline. I'm all the way down at the bottom of this page where it says 2010 to 2012. Do you see that?
I do.
And it says CSI and others conducted pump test. In this case, we've been calling that the Order 1169 pump test. Does that comport with your understanding?
It does.
So then if we turn the page, Lindsay, we're on 005 of that exhibit, just page 10 there, Ms. Rinaldi. We're in Jan 2014 at the top. It says ruling 6254 and 6255 denied all pending water rights applications in lower White River flow system, including Coyote Springs Valley, due to insufficient groundwater and threat to current holders of rights and days. You see that?
I do.
So these are the rulings, at least relevant for this case, that are reporting the results of the pump test, right?
I can't say that for with certainty.
I thought you said you'd reviewed 6254 and 55.
I did, but I don't remember which ruling said what you just stated. Excuse me.
Do you understand that at least one of those rulings reported the results of the pump test?
Sitting here today, I don't recall that the results of the pump test were in the rulings.
In either of those rulings?
Right, I don't recall.
Understood. Do you know what the lower White River flow system is?
Generally speaking, I do.
What do you understand it to mean?
I understand it to be a system of related water, groundwater, surface water that is all considered as one unit.
Do you know that an endangered fish called the Mawapa dace lives in the lower White River flow system?
I did not know I know it lives in the Muddy River, but I did not know the extent of the lower White River flow system.
Do you know that the Muddy River is part of the lower White River flow system?
I did not know that.
Do you know there are senior vested rights on the Muddy River?
Yes,
And do you understand that CSI is suing the state engineer for inverse condemnation of its Coyote Springs Valley water permits within the lower White River flow system?
I do.
You know what the consequences would be for residents of a master plan community at Coyote Springs if homes were built and the use of CSI's water permits in the lower White River flow system caused a conflict with those senior rights or the DACE?
I know that we could never get to that point. The processes for reviewing and approving development and subdivision mappings would not allow that to occur.
Do you think the state engineer would be within his rights to recommend denial of a subdivision map if he had evidence indicating that that might occur?
Yes, but he'd be required to look at all kinds of evidence.
Would he be required to pay the developer because that happened?
Objection calls
Because
for a
what
legal
happened?
conclusion.
About lay foundation for an understanding.
I'll just withdraw. We look at the entry for November 2017 in the middle of the page. It says LVVWD requested opinion of state engineer regarding ability of CSI water rights to supply water and execution of subdivision maps. You see that?
I do.
By the way, along your timeline, you didn't list any of the preceding correspondence from 2017 between LVVWD and CSI. Is there a reason for that?
I wasn't aware of it.
3539, please, Lindsay. We can split screen this, please. This is a previously admitted exhibit dated April 19th, 2017. Do you see that?
I do.
It's from the Las Vegas Valley Water District addressed to Amelia Cargill. Do you know that name?
I do.
How do you know that name?
I know that Amelia is the chief operating officer for Coyote Springs.
The subject line is Coyote Springs investment status. Do you see that?
I do.
It says, Dear Amelia. Have you ever seen this letter before?
I don't recall seeing this.
This wasn't provided to you by council informing your expert opinions that the state engineer should have signed off on the subdivision map?
I don't recall seeing this.
Lindsay, if you can get to the third page on that second part of the screen. If just read to yourself, Mr. Rinaldi, we'll end here, I think, for the day, but if you can just read that paragraph to yourself, and then I'll ask you one or two questions about it. Let me know when you're done.
I'm finished.
Okay, it says, in closing, and to avoid the potential for any misunderstanding, we must again highlight issues relating to the availability of a sustainable water resource in Coyote Spring Valley. Based on State Engineer's Ruling 6255 and the data upon which the state engineer relied, it is unclear that any substantial volume of water can be pumped on a long-term basis from Coyote Spring Valley without harming adjacent environmental resources and senior water rights. Accordingly, during our meeting, we indicated that water sourced from locations other than the Coyote Spring Valley will be necessary to support CSI's contemplated development at Coyote Springs. And we've established that Las Vegas Valley Water District is the manager as of this time of the GID, which is CSI's water purveyor, right?
Correct.
And this is the water purveyor, essentially the manager of the water purveyor, telling CSI they have concerns about harming adjacent environmental resources and senior water rights, and therefore water sourced from locations other than Coyote Spring Valley will be necessary to support development, right?
That's what it says.
Your Honor, I'm going to get stopping point if you want to end here, do that.
All right, we'll adjourn at this time and reconvene tomorrow morning at 9 a.m.
Thank you, Mr. Rinaldi.
All right.
Well, there we go, ladies and gentlemen. Thank you so much for tuning in today. I'll get that day update. We only had a half day from 1:15 p.m. Tomorrow we'll be back here at 9 a.m. You were watching W4Nevada Live's continuing coverage, day 14 of Coyote Springs LLC versus the state of Nevada. I've appreciated each and every one of you that have tuned in. If you've just started watching today, thank you so much today. Make sure to share it out, as it is very hard to get visibility on things like this. I'm not sure why it is that they try to hide just publicly available things that if you had gone to view these things by yourself and or had the availability to, it would be there. However, it's necessary for someone like myself and or an entity like what we are doing to be able to get this public out. You had to file documentation with the court in order to get the permission to be able to put this out to the media in a way at which I am. It truly just, it means a lot to be able to have people that do tune into this, because I know it's boring. Trust me, I'm watching it. But the reality of what's going on behind the boring, or the bore, whatever it is you want to call it, the I don't know, the inactivity of sitting there and watching somebody for hours on end drain over questions that don't really apply to you, yet they do in the finality of a decision if it was something that you were not to pay attention to. So it is important. It will set precedent. We're talking about $1.5 billion from speculative land developers and realty. And it's the same thing. Like, imagine the data center right now not being able to build because you got it banned from the basin 162 in Pahrump, right? And then imagine that now, since they can't build, they're allowed to sue you for the potentiality of possible earnings that they may have made, even though in the midst of not making that money, not being able to develop, they were pumping water that was the natural resource and selling it at an exponential rate, which right now is going for as high as $20,000 an acre foot. So when you start to sell, you're talking about millions of dollars. And when you're talking about thousands of acre feet, you're talking about hundreds of millions of dollars. Repeated again and again over a period of nearly 30 years. And this has been going on in all 17 counties. Agriculture, mining, companies, and land development like this. Earlier, Sangatsi Peak out of Lyon County, I was able to pull a document because Rick Remke sent something to me. Shout out to Rick Remke. You have to pay attention to everything at all times and what affects you in your areas. And what is most important to continue to report on and or keep in the eye of the public. Which is why W4Nevada is Nevada's network. We don't get paid. I'm not asking it. I'm not asking for anything. I don't want anything at all except for transparency, accountability, and for Nevada to be for Nevadans. That's it. All 17 counties. And to remember that there are 17 counties. And I remember that every day. And I take it into consideration. And I make sure that every step that I make is in the name of or in the benefit of every fellow Nevadan that I have. Whether it's the 3.5 million on paper, the 4.5+ million off paper. It matters to me. You matter to me. Each and every one of you. Not just the two in the sports book. So Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, White Pine. I want you to know that it's not just two in a sports book. And when you think about that, you have to just remember, as I tell you every day, that we're not just Vegas, folks.
We're not just Vegas, you're not. Read the whole map, read it. Lights don't run the state, no they don't. That's a small cap, small cap. We're not just Vegas, look around. Past the neon haze, past it. 17 counties, all of them. Different lives, same place, same soil, same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. There's towns where a handshake still means something. Where folks know the land and the seasons are blunting. Where work don't trend and patience is learned. Where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boots, dusty coffee. Some places quiet, some places spread. Some rows, long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way, no way. That service talk, surface, surface. Real Nevada, out here, outside the wall, outside, outside. This land where the sky feel heavy or blue. Where the silence louder than the news. Places built slow, no rush to impress. Where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around. We don't move fast, cause we plan ahead.